Morning, Your Honor.
Shannon, put us on the record, please. Good morning. First up is Donahue versus Wisner. Mr. Wisner.
Your Honor, my client's here. My client's here in my waiting room. He's not in my office. If I can just step out and go get him, Your Honor.
Okay.
Thank you.
Shannon, Ms. Donahue is present.
Thank you.
Hello.
Okay, Your Honor, thank you for letting me get my client. He's in my office now.
Okay, thank you. Ms. Donahue, this is your motion regarding custody. You are asking the court to consider changing custody of your son Joshua from Mr. Wisner's, from Mr. Wisner to you. Is that correct?
Yes.
The reasons you've given in your motion are that you're in a better place now and are better able to care for her than you have been in the past, for him rather. You've addressed medical and mental health needs that you don't believe the father is properly attending to. What specifically, what needs does your son have?
Well, he is on ADHD medication, and he was off of it for about a month and a half to 2 months. And I had got him back into the doctors and got him back on it. And he also, he needs to be in therapy, which I also got started for him. That Mr. Wisner wasn't getting him done. I addressed this to him for the past 3 years, and it was excuse after excuse when I've asked him to do it. And I've asked him for his insurance information because I would have done it myself and got him back and forth, but he never got back with me. So when I took him into his doctor's appointment to get him back on his medication, I talked to his doctor about therapy and got him settled in therapy.
Any other reason that you have that may not be stated in your motion as to why you think that a change of custody would be in Joshua's best interest?
Yeah, Joshua's father, Mr. Wisner, he's working a lot. He's hardly home. And so 90% of Joshua's care is being put onto his ex-wife, whom he's not even with anymore. They're just living together. And I feel that, you know, Joshua would be better living with me because I'm home, so I can take care of him, make sure he gets his medical attention he needs, give him the physical attention he needs, and everything. And Joshua has stated that he would like to live with me. So, and like I said, I am in a better place now, so I would love to have a chance to raise my son again.
Okay, thank you. Mr. Valley?
Thank you, Your Honor. We'd ask the court to deny the motion as proper cause and change in circumstances have not been established by Ms. Donahue. The main facts here, as the court's indicated, is that my client has had, the father has had custody of this child since 2012, so it's been about 8 years. Regarding the therapy situation, my client has always addressed those needs for the child. I think I indicated that in our response, but just as a basic overview, Joshua was in homebound therapy from 2012 to 2015. He was at Catholic Social Services for some therapy from 15 to 16. And then from 2016 through June of 2020, he was meeting regularly with the school council. And now he's back in therapy at the Center for Family Health. And so there's been consistent and ongoing therapy for the entire time that my clients had custody of this child. I would point out as well that there was an abuse and neglect case back in 2012 against the mother, and that's the reason that the child ultimately was placed with my client. The child's doing well in every respect. I just asked my client briefly about the ADHD medication situation, and all that was there was one missed call from the doctor during the COVID situation. But that's all been resolved now. There's been no significant issues or problems with this child. What we have here, and I guess I understand where Ms. Donahue is coming from, she just wants more time. But under the law, that's not enough. In fact, she has Thursday parenting time that she hasn't even been exercising in the past 4 months. And so some of the parenting time she has now, she hasn't even been utilizing. And so we would just ask the court to find there's not enough here, not proper cause, there's no change in circumstances. Everything has been proceeding forward pursuant to the status quo that's been established over the years. And we'd ask the court to deny the motion and consider an award of attorney fees against the mother.
So my understanding of the threshold is that there must be a change in circumstance or other good cause that impacts at least one of the best interest factors. Mom has alleged that dad has neglected both physical and mental health needs of the child. If that's true, that's enough to at least address the threshold. I understand there's a dispute of fact over those things. I think she's alleged enough for the court to order an evidentiary hearing, but the very first issue that would have to be addressed at an evidentiary hearing is if, in fact, that threshold has been met. If she does not factually establish that the father has been neglectful of physical or mental health needs of the son, that's the end of the hearing. The court would not be allowed to order a change of custody if that threshold is not met. I'm assuming, Mr. Fallahy, you would like that in front of the court?
Oh, yes, please, Your Honor.
All right, I'll have Dawn find a date for you, and we'll get this on the docket.
Okay, thank you, Your Honor. Do you need me to prepare an order that reflects the court's ruling today, or not really, just because we're going to be having the evidentiary hearing? I guess I just want to make sure that there's something in the file that reflects that the evidentiary hearing will start with the issues of proper cause and change in circumstances.
I will, yeah, why don't you submit an order? Once we get that order, put in a blank date for the date of the evidentiary hearing, and I'll have Dawn find you a date.
Thank you, Your Honor.
Thank you.
Judge, I have one more hearing with you. I think Mr. Whiting's on the other side. I don't know if he's ready yet, but if you want to put me back in the waiting room, I'll just be here when you need me.
Mr. Whiting's across the hall.
Mr. Whiting is across the hall, so. Okay, next up is Stinson versus Stinson. Ms. Payne is present by Zoom, Shannon, and both parties are also present.
Thank you.
And Ms. Hamilton, this is your motion for an order to show cause?
Yes, thank you, Your Honor. Before I proceed, I'd like to point out to the court that we are here on a motion for order to show cause, but after the
Oh,
order
just a second. Mr. Stinson, can you hear me? He spoke up is the reason I stopped you. Apparently, he's having trouble hearing me. Obviously, we heard him.
I heard him. I'll text him, Judge.
Mr. Stinson? If he is having trouble making the connection, if you've got a telephone number, I can call him so that he can hear the proceeding.
Sure. Are you ready for the number, Your Honor?
Go ahead.
It's 616-634-6802.
Are you letting him know that I'm calling?
Yes, I'm texting him now.
Okay.
Judge, he just texted me saying he can't answer. Oh, I'll just tell him to log off. So he can answer.
Okay.
You may have to call again.
Captain Stinson.
Good morning, Mr. Stinson. This is Judge LaFlamme.
Good morning, Your Honor.
We could hear you on the Zoom, but apparently you couldn't hear us, so we're going to let you participate by phone.
Thank you, Your Honor. I appreciate that.
Okay, go ahead, Ms. Hamilton.
Thank you very much, Your Honor. We're here on a motion for order to show cause for the defendant's failure to comply with the order that you ruled on August 20th. However, that order was entered, the August 20th order resulted, your ruling on August 20th resulted in a September 3rd order, which Ms. Payne approved. But after it was entered with the court, I got a telephone call from the Jackson County friend of the court advising me that there needed to be a minor adjustment which should not affect today's proceedings at all. The adjustment is there was apparently, after the friend of the court's February child support order was entered, but before you set it aside, there was one child support payment in the amount of $996 that actually was captured via an order of income withholding, and it was submitted to Ms. Stinson. It was issued and sent out to her. It had been our understanding in our conversations with the friend of the court prior to that that there were no support payments issued to her. The friend of the court suggested that to correct that issue in our order, which has already been entered. It's corrected if we make 2 tweaks. And I have prepared a written adjusted order that makes the tweaks so that it will be clear to the front of the court and the parties. Now, mind you, this is an order, we're tweaking the order that has been approved by Ms. Payne. And the tweaks are as follows. In order to reflect that one child support payment of $996, we need to adjust the date that Mr. Stinson would be paid through if he complies with your ruling, which he has not done so far, and he's substantially delinquent on that. Your order was that he would pay $6,972, which would cover his support obligation pending further inquiry by the court for the period from February 1st through August 30th. Friend of the court has suggested that we just change that and make him current on his obligation from February 1st through September 30th. Does that make sense?
And
Give him
that,
1 month credit.
so you don't change the number, you just give him an extra month credit.
Correct. He hasn't paid it yet anyway.
Okay?
But that also results in one more tweak. You had ruled that pending further order of the court, an inquiry into Mr. Stinson's actual earnings, including the BAH and BAS allowances if applicable, that he would continue to pay the $996 until we had the entire issue resolved. And he was to pay that $996 per month starting September 1st. But after we make this tweak, it only makes mathematical sense if we start his obligation 1 month later. And I felt that because that's all to his benefit, there wouldn't be any objection in our making those adjustments. If we had, pre-COVID, all the parties here, we could hand each other orders and get them approved and signed, but we can't really do that right now. Those are the only 2 tweaks in the adjusted order that I have in front of me. If you want to look at that September 3rd order, I can tell you exactly where the changes are, or did you already find them?
I've got I've got a copy in front of me that I've been scribbling on.
Okay, so it shows up in the first line on page 2, you change, oh wait, it's not the first line. It's the second to the last line of the top paragraph.
Change August 31 to September 30.
Correct.
Okay?
And then on page 3, top line, change September 1st to October 1st.
Oh, great. I just looked up and I see Ms. Payne is no longer, let me see if she logged back in.
No, Your Honor, this is Mr. Stinson. I'm sorry, I just got a text message from my attorney. She said that she was kicked off of the Zoom meeting, but I think we can proceed. I'm prepared to speak to what happened here, or what I'm able to do.
I can't hear him at all, Your Honor.
Well, we lost Ms. Payne. He simply was confirming that we lost her. I'm watching the waiting room to see if she hasn't logged back in yet. But Mr. Captain Stinson was saying that he was willing to proceed without her.
Oh, perfect. Well, that was going to be the irregularity that I wanted to touch base on before proceeding. So if he's willing to proceed without her, I guess I have to say, does she have any objection to that?
Well, I don't know, because she's not here.
I just don't want to come back, I don't want to have to come back and do this again.
I think the client can decide to proceed without his attorney if he wants to.
I do too.
So,
I'm prepared to do so, Your Honor.
go ahead, Captain.
So unfortunately, I'm not sure if paperwork that I submitted ever made it to the court. But a little bit of a backstory that it's true. I was ordered to pay child support in February. Attorney Hamilton just mentioned an income withholding payment that went to Christie. That is incorrect. I paid in February. Immediately they filed a motion, and then everything ended up on hold. I actually made 5 payments through the MISDU, and they were all refunded back to me. When I contacted them in June, they stated that I had no obligation. The hearing that occurred in August, I was never made aware of. Therefore, I couldn't comply with any orders to pay by September 3rd. I don't disagree at all that there's a $996 child support obligation. I'm fully willing and able to pay those months that have not been paid. I would like to see a full accounting of what Christie has received, because I'm not sure that between myself, her, and the MISDU that there's an actual good accounting of payments up to this point. Further, so we talked about, Attorney Hamilton talked about shifting the September 1st to the October 1st date. Now that I know that the payments there's a method by which I can pay, the September check is in the mail. So that should be received by the MISDU any day now.
All right, so I want to make sure you understand what Ms. Hamilton is proposing. It sounds like it matches with what you told me, but let me make sure of that. The amount that is in my order of September 10th was based on the amount that would be necessary to bring your account current through the end of August. And what we learned after this order was signed is that in fact you had made one payment of $996. So what the adjustment she's proposing is that with that payment, your account, this amount that's in the order would, if paid, make you current through the end of September. If you've already made another payment since then that just hasn't made its way through, you would get credit for that based on the language of this order.
Yes, Your Honor, I understand that. Unfortunately, I don't have the financial wherewithal to have credits.
I don't understand. What do you mean?
So $7,000 is what she's proposed, roughly $7,000. By my bookkeeping and accounting, it's between $4,980 and $5,976. Understood the credit. I've got a check that's processing at this time, which will get me current for the month of September. So I guess I'm here. I'm willing to get those months that are missing taken care of, but I am not able to pay a forward and receive a credit.
All right. I think maybe you didn't understand me. Ms. Hamilton, the amount that's in here, the lump sum of $6,972, I'm assuming that is a number of months, an equal number of months divisible by the 996 monthly amount?
Yes.
How many months is that?
February, March, April, May, June, July, August, September, 8 months.
8 months. So let me.
I'm going to ask Christy Stinson to do that calculation on the calculator right now.
I'm pulling up my Excel and I'm going to do it.
Oh, you know what? I have to think about how that credit we're giving him for the March payment works. February, March, April, May, June, July.
Your Honor, February is paid and September is processing. So there should be a total five months that are missing,
I
which I'm
get-
able to.
All right, I understand what you're saying, sir. I'm just trying to come up with a number. Yeah, that's not 8 times 996.
If we could take,
It's
go ahead, Christy, did you do it?
it's 7 months. It's February through August, the end of August.
Because March was paid.
All right, hold on a minute. Okay, so yes, that matches 6972. We know from what Mr. Stinson has told us and what the friend of the court has confirmed to you that one payment of $996 has been processed and has made its way to Ms. Stinson. And Mr. Stinson is saying there's another payment that's currently in process. It just hasn't been credited yet.
I have lots to say, Your Honor, but I want you to.
Which would leave a balance due of $49.80. Does that match your number, Captain?
It does, Your Honor. Thank you.
So, I think the changes proposed by Ms. Hamilton are accurate, and the order wouldn't require you to pay an extra $996 if you've already paid that $996. You'd get credit for that, is what I'm saying. So that the lump sum amount you'd have to come up with is $49.80.
Yes, Your Honor.
With one caveat,
Hold on, let me, go ahead, Ms. Hamilton.
because payments through the friend of the court are delayed by virtue of the need to process the order of income withholding, we specifically set up, and his attorney approved an order requiring him to pay the payments directly to my office so that we could hand him a direct credit, which we would then process ourselves.
Well, the problem is he's already got a payment in process, Ms. Hamilton. Shouldn't he get credit for that?
Yes, absolutely, and we will give him the same direct credit as soon as we can confirm that September payment is received, if he brings in the amount you ordered less $996. We're happy to do that.
Which is $49.80.
Exactly.
I think that's what we're talking about.
But I
So
want,
I don't understand your caveat.
I want him to bring it to the office as you ordered, instead of process it through the friend of the court.
The $49.80.
Correct, and we will give him a direct credit for $49.80 as soon as we can confirm that we have that check in our hand and that the friend of the court has received the $996 he says he just sent.
So, Captain Stinson, this $49.80, the requirement would be that you send the check to Ms. Hamilton instead of Ms. Stinson so that she can give you a direct credit for it upon its receipt.
Or he can deliver it, he lives in Jackson.
Oh, okay, somehow I was thinking
No,
it
he
wasn't
lives
here.
on Dixon Road in Jackson.
That's not a problem for you, is it, sir?
So just to understand what you said, Your Honor, send the check to Miss Hamilton, and then she will direct credit to Miss Stinson.
She will issue you a direct, hold on, Ms. Payne has made it back in. Let me get her in. Okay, Ms. Payne, you're back.
Yes, sorry, I don't know what happened. It stopped, the audio stopped and I dropped out. I just hung up because I was trying to call in on my office line.
Okay, I think because Mr. Stinson authorizes to move forward without you, that we've made a resolution that
Okay.
we're all on the same page. He's got a payment that's in process that he's going to get credit for.
Yes, he does, Judge. Just 1 second here. I'm sorry. I think he was trying to call me. He has a payment. He had made several payments to Ms. Due that were coming back to him, which I was not aware of. And so he has the balance due, the balance that's due he has to pay.
He told us all about that.
Great.
So
Okay.
what we were able to figure out is the payment, and he's in agreement with this payment. The payment would be $4,980. He's gonna either deliver or mail the payment directly to Ms. Hamilton.
Great.
And when she gets it, she will see that a credit is issued for that amount.
Great.
May I interrupt?
Yes, go ahead, Ms. Hamilton.
You previously ordered the 6972, which I'm not arguing about. The 4,900 figured is fine, but you previously ordered that to be delivered to my office by September 3rd. Since we're now October, can you require Mr. Stinson to bring that $4,900 check to my office so that we don't have to wait for the 14-day mail lag? Ms. Stinson has not had any support from him other than the $996 we were alerted to by the friend of the court since October of 2019.
And so, Captain, let me ask you, how quickly could you actually deliver that check to Ms. Hamilton's office?
I can get it by Wednesday of next week, Your Honor.
That's a full year.
Wednesday of next week is acceptable. So I'm going to modify this order that's in front of me. Now, so that's going to put us to
Should be October 7th.
October 7th.
Your Honor, this is Captain Stinson again, if I may.
Go ahead.
I need to make sure that I have protections from friend of the court and some of these other actions reporting to credit bureaus, for example, for arrearages. These arrearages were not caused by any fault of my own. So I want to make sure that that this is all taken care of.
Mr. Stinson, once the credit is issued, you won't be getting those automatic mailings. So once Ms. Hamilton provides the credit form to the front of the court, it'll show 0, and you will not receive those mailings or warning letters from the front of the court anymore. And I'm sure she'll do that promptly.
I've also had my my employer, my boss, my commander's been contacted now. There's been a lot of things here. Just want to make sure that I'm protected from all of those negative effects of something that I had no, it wasn't an intent of mine.
Okay, so the modifications I made to this order, which I've entitled First Amended Order Regarding Child Support After 8/20/20 Hearing. Page 2, on or before October 7, 2020, defendant shall pay plaintiff the sum of $4,980 by delivering the same to offices of Janet Hamilton. Defendant shall receive a fully executed direct credit form at the time of payment, providing a direct credit against his child support obligation for the sum of $4,980. Said sum represents child support from April 1 of 2020 through September 30 of 2020. Now, obviously, this assumes not only, well, the payment that everybody acknowledges, but the one that's in process gets made.
Then you need to put that in the order, Your Honor, because we typically don't get the things that we hear we're getting.
This would only give him a credit for April through September.
Right.
If he hasn't paid or it isn't in process, he would still owe the March payment.
Right.
He can only have the September credit. Maybe I'm not following your math, but he can only have the September credit if we actually get that payment he claims he processed. I don't know, maybe you could ask him when he sent it or if he hasn't sent it yet.
Your Honor, sorry.
Go ahead, Captain.
It should be March through August, Your Honor.
I mean, we end up in the same place, don't we?
That is correct.
If you don't, this is only going to credit you with 7 months. What months we apply them to, I don't think matters that much.
Remain at all.
And if you've got a payment in process, along with the one that has already been processed, this will bring you current through September 30th.
I agree, Your Honor.
Okay, I think it gets us to the same place.
I think it cuts Mrs. Stinson out one payment, but,
No, it doesn't.
okay.
I'm only giving him credit for 7 payments. If he hasn't made payments 8 and payments 9, he'll still be responsible for those. All right.
There's much, much more, Your Honor, and that was only to address the fact that I uncovered the need for an adjustment in the order to be fair to Mr. Stinson. But there's
Wait a
more
minute.
that's up.
All right, so at least we're square on how much he needs to pay in order to get current. So go ahead with whatever else you think I need to address.
Mr. Stinson was supposed to also produce directly to my office complete earnings information pursuant to your order by September 17th, disclosing his total income, including the BAH and the BAS supplements. He has also failed to do that, which we've ordered the friend of the court to recalculate child support, but they still don't have the information that they need to calculate accurate child support until we get that.
Okay, Ms. Payne,
Yes.
you want to
Miss-
respond to that?
Captain Stinson sent that information directly to the friend of the court. He did not know he had to send it to Miss Hamilton as well. Apparently, he missed the communication from my office, which is the first time in the several years I've been working with him that that's happened. I'm certain that it was not his intent to do that. And I believe that the court actually forwarded a copy of the materials directly to Miss Hamilton's office because it looked like it was being submitted ex parte. Again, not intentionally, but she should have it now because she responded to the email that he had sent to everybody.
I didn't respond to any email Mr. Stinson sent.
Did you get the material?
I did not get the material, and I confirmed with the friend of the court this week that they don't have it either. Now, it might have come in yesterday,
It
but I'm
did.
supposed to have it.
I'll forward
And
it
this
to you
is
right now. It
related to
did.
child support.
Ms. Payne, can you copy the court with that?
Yes, I can. It's dated Tuesday, September 29th. I will forward to Ms. Hamilton's office and to the court.
Send it to P. Veldkamp, PVELDKAMP at mijackson.org.
Okay. I'm doing that from my other laptop right now, Judge.
Okay? Peter, let me know when you get that.
Your Honor, Captain Stinson, I apologize if I'm speaking out of turn. I know child support, and I'm not disputing that, but we really need to get custody and parenting time figured out at some point so that I can, number one, have enough time with my son and be a parent, and then figure out the support obligations and have it reflect accurately. They keep talking about BAH and BAS, and I don't know that Attorney Hamilton truly understands how the military pay system works. I am an active duty soldier, and as an active duty soldier, the government is to provide me housing. If I lived next to a large installation, I would live in on-post housing and therefore not receive BAH for housing. I've got a family, I've got 2 stepchildren, I've got a new baby, and we're probably going to have another child. That money is for my family. I don't know that it should necessarily be included in my pay, as it's not pay, it's an entitlement.
Captain Stinson, that's something for you and I to discuss. That's not something the judge can address. Those are questions direct to me.
I don't want you misled, Your Honor. This was the subject of a motion that we filed in
Right.
March that they moved on an emergency basis, and the child support guidelines require the BAS and BAH specifically to be
Right.
included.
Captain Stinson and I have
don't-
discussed that. Sorry, Judge. Captain Stinson and I have discussed that already, and he can direct any of those questions to me after the hearing.
Okay, and there was something else, Ms. Hamilton?
Well, I do want to clarify, are you declining to enter in order to show cause down the road to see if we can get compliance with this $4,900 requirement and the $996 by next week?
If you don't get the 4980 by October 7th, yes.
Do I need to bring another motion?
Well, of course.
Another motion for order to show cause?
You can renotice this one. How's that? That'll save you a motion fee.
Okay, and the earnings information has been sent?
We're waiting for confirmation.
Then may I also just add that we filed this week another motion to address a parenting time issue, as Mr. Stinson believes that the parenting time weekends he's entitled to under the judgment are supposed to be reversed. We don't understand why, but I just want to let you know we've already filed that. It's not something we're doing on a
Yeah.
retaliatory basis. It just went through this week.
There's also
and-
9 time complaints floating out there on our side. So you will be seeing us again on the custody and parenting time issues, Judge. It's not up for today.
It's not up for today, that's correct.
No.
We have copies of that order, Your Honor, once you get the confirmation that the BAS, and I'd like to see the BAS and BAS, the leave and earning statement. I'd like to see when it comes through.
If your clerk doesn't see it, check spam. Sometimes my emails go to spam the first time. There's 2.
He's
One
got
has
it.
you got, okay, there should be 2 of them.
Does that show Ms. Hamilton as being a recipient?
Let me just
Jay
confirm on
Hammy at
my
SBC
phone.
Global.
Yeah,
That is correct.
I have.
Yes. So it looks like it's been sent. So, Peter, I want you to make a copy of this order for Ms. Hamilton.
But I've received copies of payments.
That's the second email, Ms. Hamilton. There's one before that as well. I just wanted you to see the return payments from Ms. Due.
We already know that payments were, Mr. Stinson actually got those payments back and he cashed the checks on June 19th. So he got his child support back.
I just wanted you to see all the paperwork, that's all.
I don't see a leave and earnings statement. Did you send a leave and earnings statement?
They're attached to both emails, so go to the one prior to the one you just opened, and you're going to
Got it.
see several months of
Got
them.
it.
Okay.
Got it. Thank you.
Anything else for us,
Yeah.
Judge?
It doesn't look like it. I've signed the order.
Thank you, take
I'd
care.
like to just, before we sign off, I'd like to ask Ms. Stinson if she has anything. She's been
I do not.
patiently waiting.
I do not.
Thank you. Thank you.
Okay, thank you all.
Thank you, Your Honor.
Have a good day, sir.
You too.
Okay, let's see. Okay, next up is Fierro versus Fierro. Joseph and Crystal Fierro are present. Mr. Hotchkiss is present, and we're waiting for Mr. Rapley's connection to come through.
I think you called the wrong case, Judge.
Oh, I'm sorry. You're right. No, I got the wrong attorneys. It's Whiting and Fallahy. My apologies. I looked at the wrong line.
So Fierro.
No, the next one up is Mayatki versus Mayatki. So the Fierros are on the next case. And I'm still, for some reason, Mr. Hotchkiss having trouble getting a connection with Mr. Rapley.
I was texting.
It shows that he's joining, but he's, here we go. Here we go. Are either of you expecting, this is Mayatki versus Mayatki, are either of you expecting clients to participate?
No, Your Honor.
Okay, this is showing as a status conference. What's going on with this case?
Your Honor, you signed an order for the parties to go to arbitration, binding arbitration. That arbitration date has been scheduled. It's 2 or 3 weeks out from today's date, but that should resolve and will resolve the issue.
Okay, fair enough. Sorry to trouble you, gentlemen. Have a good day.
Thank you.
Yeah.
Okay, now we're ready for Fierro versus Fierro. Mr. and Mrs. Fierro are both present. Michael Fallahy is present, and I'm hoping that's Mr. Whiting on the iPhone. Waiting for that connection to come through. Did you say he was in the building?
Yeah, he's across the hall, Judge.
Oh, so that's not him.
I don't see his bag over there. I thought he must have grabbed his bag.
Your Honor, I'm sorry, the one with Ken and Mr. Rapley?
They're arbitrating the divorce.
Okay.
So the status conference should have been removed when that order was entered.
Thank you.
Well, apparently we're still waiting on Mr. Whiting, who's tied up across the hall. I don't know who the iPhone is, but it's not coming through. So you folks sit tight till we hear from Mr. Whiting. Uh, and we're a little bit early on Morochka pretrial.
Do you see Ms. Fleming? She was planning to be here. That should just be a pro con, Judge.
Oh, okay.
We've been exchanging the judgment back and forth.
All right, well, we're 5 minutes early, so.
I had other hearings in the building, so it was easier just to be in person.
Well, as soon as she gets here then, let me know.
And we'll need her tonight.
And you can take us off the record. Let me find out who this is on the iPhone. Mr. Morochka is now here. I'll let him in. Looks like we're having trouble making the connection. Can I ask who it is that's on the iPhone?
I'm on an. Good morning. Good morning.
Yes, what's your name? Yes, sir. What is your name?
Stevenson. I was just trying to log in the Zoom meeting.
And your name is Stevenson?
Yes, Stevenson Storm.
Yeah, I think you might be in the wrong meeting room, sir. I don't have a case with your name on my docket this morning.
Okay.
This is Judge LaFlamme's courtroom?
Yes, that's the one that I have.
I'm not seeing.
But it's I was just trying the Zoom meeting just to see if it's gonna work, but I think my court hearing is at 10:30. Yeah, it's at.
Oh, okay.
Yes.
All right, I see that now.
Okay.
All right. We'll put him back in the waiting room. And Ms. Fleming is now here.
Mr. White.
Well, he's gonna get to wait. He made it first. Mr. Morochka, can you hear me? Okay, Shannon, put us back on the record.
Go ahead.
This is the matter of Morochka versus Cook. Is that how it's pronounced?
You can look at the courtroom like I can see. Crystal's in the living room, or she's in the dining room, but you won't look.
And my client won't be participating, Judge. If we can just do the pro con. Ms. Fleming, did you get that latest version of the judgment?
I did.
Okay, good.
So Mr. Morochka is having trouble making an audio connection. Do you happen to have his phone number?
He's Ms. Fleming's client.
Do you have
I
his
do,
phone number,
Judge.
Ms. Fleming?
I do. It's 206-1946.
If you could shoot him a quick text, ask him to hang up his phone, and I'm going to be calling him.
Okay. I'm trying.
Mr. Morochka? Yeah, I'm afraid he's trying to use his phone to make this connection. I'm gonna try again. I just rang 3 times and then nothing. Hello? Yeah, he probably thinks it's a sales call.
There he is.
Mr. Morochka?
Oh, he disappeared.
I see that. I'm gonna try again.
Okay.
This is Dean.
Mr. Morochka, this is Judge LaFlamme.
Good morning.
We were obviously having trouble making a audio and video connection over Zoom, but this works fine.
Okay. I could see you guys on video. I just couldn't hear anybody.
Yeah, we couldn't hear you. Okay, I understand, Ms. Fleming, you are going to be entering proofs today.
Yes.
Mr. Morochka, can I ask you to raise your right hand, please?
Yes,
You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your full name.
Dean Joseph Maraska.
And pardon me for butchering your name. Go ahead, Ms. Fleming.
Thank you. Dean, you recall signing a complaint for divorce earlier this spring, is that correct?
Yes,
And were those statements contained in the complaint for divorce true on the day you signed it?
yes,
Specifically, had you been a resident of the county of Jackson for at least 10 days before signing the complaint?
yes,
And a resident of the state of Michigan for at least 180 days before signing the complaint?
yes,
And there's one minor child of the marriage, Colton, is that correct?
yes,
And to the best of your knowledge, is your wife pregnant today?
she is not.
Has there been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed?
Yes,
Is there any reasonable likelihood that your marriage can be preserved?
no,
And we have been participating in settlement negotiations, correct?
yes,
We have reached an agreement regarding joint custody, joint legal custody, joint physical custody, and equal parenting time, correct?
correct.
And you believe that to be in the best interest of your son?
Yes, I do.
And we have come to terms regarding a property settlement. And you understand that once we sign the judgment of divorce, it becomes final and it will not be modifiable by the court. It can only be enforced. You understand that?
Yes, I do.
And the terms relating the custody, parenting time, and child support for your son may only be modified upon a showing of a change in circumstances. You understand that?
Yes,
And so when we present the written judgment and uniform child support order signed by all of us to the court, are you asking the court to enter it into grant a final divorce?
kind of broke up there, but I'm going to say yes.
Okay, so once we sign everything, you want the judge to grant a divorce?
Yes,
Okay, thank you, Judge. I do have the most recent revision from Ms. Danke, which my client has preliminarily approved. We just haven't logistically gathered the signatures together. And once we do, we will present it to the court for entry.
Thank you. I am satisfied based on the proofs that there's been a breakdown in the marriage. To the extent the objects of matrimony have been destroyed, there remains no reasonable likelihood the marriage can be preserved. We'll change the October 15 trial date to a status conference. If the judgment is in before then, there will be no need to appear. Thank you all. That concludes our hearing.
Thank you, Judge.
Great.
Have a good day.
Thank you, Judge. Thank you,
you.
Susan.
Okay, now I think we're ready for Fierro. Mr. Whiting is present.
We good, Judge?
Mr. and Mrs. Yes, have a good day, sir. Sorry.
Yep, bye.
Mr. Fallahy is present via Zoom, as are the two parties. Okay, and we're here then, I guess, Mr. Fallahy, on your client's objections to the ex parte order.
Yes, sir.
Go ahead.
Thank you, Judge. As you'll see from the court file, the ex parte order in this case was entered while you were out of the office. It appears to have been signed by Judge McBain. What we have in this case, Judge, is a situation where the plaintiff has just blatantly made false statements about my client to continue her plan to get him out of the marital home. I have significant information from a lot of other witnesses that have indicated that her plan was to ruin my client, essentially have him removed from the home, try to keep the children from him, and ruin his life. And she's done a nice job of that so far in this case. What I'd like to do is specifically focus on a couple of allegations in the motion. I believe it was paragraph 2 of the motion had indicated that my client had moved out of the home. That is patently false. My client indicated he's lived in the home for the entirety of this marriage, more than 10 years, and he's only stayed away from the marital home about 10 nights in 10 years. But Ms. Fierro wants the court to believe that my client had moved out to support her, again, false motion for an ex parte order. If the allegations in Ms. Fierro's complaint, and if the allegations in her motion were true, she had a simple solution. She could have left. She didn't. She essentially made up these false allegations and forced my client from the home against his will. It's the home that he's lived in for 10 years. My client is not a violent person. I've talked specifically with him about this. He denies that he's ever physically assaulted the plaintiff. He indicated to me that the plaintiff mother is a pretty heavy drinker. And when she drinks, she may have problems remembering some of the incidents that may have occurred from the evenings before, but she is the aggressive person. Again, I have witnesses who will verify that. I also have a Facebook post just recently from Ms. Fierro that shows a picture of what appears to be two alcoholic drinks and says, "When are we going to be having a liquid dinner again?" She's a big drinker, Judge, and obviously it clouds her ability to determine between fact and fiction. My client, I would point out as well, Judge, and I mean no disrespect at all to my client, but he's disabled, Your Honor. He's physically disabled. He, in my opinion, and I've met with him a few times now and we've talked on the phone, he doesn't have the ability, in my opinion, to do the things physically to the plaintiff that she's alleged. And I know that obviously Mr. Whiting's in the courtroom and we are on Zoom, so you can't see my client right now, but he has difficulty ambulating and moving around the room. And so I've explained to Mr. Whiting, if the allegations in the plaintiff's motion were true, he could have simply walked away from my client. and it also seems that if there were injuries recently or domestic violence, there sure would have been a police report attached to the motion. There wasn't. There may have been medical records attached to the motion to substantiate this broken finger. There wasn't. There was nothing attached other than her baseless allegations. My client essentially is this monster that he's not. So this motion is disappointing, obviously, on a lot of levels. And my client would like to move back into the home. I've suggested that the court enter, at least on a temporary basis, a nesting arrangement, which would require zero contact between the parties, and it would put them on equal ground as it relates to moving forward in this case. My client's position, Judge, that Ms. Fierro did this maliciously, that she did this to try to gain an advantage as it relates to custody and parenting time. As I indicated in my response to the motion, my client is and always has been the primary caregiver to these children. Ms. Fierro works. Ms. Fierro was in school. My client has been a stay-at-home father for the entirety of the children's lives. His only income is Social Security, and he's been declared disabled. And so he's always at the home. I would further point out that Ms. Fierro, interestingly, and I think it's in the order, Judge, that Ms. Fierro wants to keep the status quo as it relates to payment of the bills related to the home. Interestingly, my client pays the mortgage on the home. She not only wants my client, who gets $1,000 a month, so his annual income is $12,000, pay the mortgage on a home that he can't even reside in while she lives there with the children, and essentially has been controlling the parenting time since my client moved out. With that being said, in anticipation of what Mr. Whiting might say, the parties have been essentially, for just the past couple weeks, my client's been having every other weekend, because I told him and instructed him that he needs to get whatever parenting time he can right now until we can get this situation resolved. My client very much objects to any type of him being in any type of a non-custodial, at a minimum, joint custodial situation. And again, it sounds like the court's going to need to hear from some witnesses, but I think the parties need to be on equal ground until the court can hear from those witnesses. My client would request, as I indicated, that the court at this point, and we have conciliation in a few weeks, Judge, I would ask the court to enter either a 2-2-3 or a 5-2 parenting time schedule until we get to conciliation, and require the parties to nest at the marital home, which again doesn't happen very often, but it would be appropriate in this case so that the parties don't need to have any contact, that the parent exercising his or her parenting time would remain at the home and the other parent would go elsewhere. Point out that both parties have family locally. They have a place where they could go and stay. And it would be just as easy for Ms. Fierro to move out as it would be for my client. So we would specifically ask the court to set aside the parte order relative to the exclusive use of the marital home. We'd ask the court to enter at least a temporary parenting time order. We're not requesting custody today, but some type of parenting time order so that the parties don't have sole authority or control over the parenting time. Order the parties to utilize a nesting arrangement for their parenting time until we can get the order from conciliation, which, as this court is aware, probably happen, maybe a month or so after the actual conciliation meeting. And if it's found, I would ask the court to reserve on the issue of attorney fees, because proven that plaintiff's allegations in this motion were in fact false, then we would ask the court to order that she pay all of my client's attorney fees relative to this objection, set aside the ex parte order, and to defend this motion. Thank you, Your Honor.
Thank you. Mr. Whiting?
Your Honor, we largely disagree with everything that Mr. Fallahy just said. As far as the false statements made in the original motion, ex parte motion, that there has been physical abuse suffered by my client, we have two witnesses, Hannah Rose, who witnessed the facial bruises on her face, and a registered nurse who also happens to be a co-worker, Sarah Teller, that would testify to the physical abuse that was witnessed with bruises and whatnot.
So these witnesses would testify to bruises, or they would testify to seeing the bruises inflicted?
They would testify that she suffered injuries. Furthermore, my client has been counseling over both the physical and mental abuse that's been suffered by from her husband. Since the exclusive use order has been entered in, Mr. Fierro has continued to drive by and take note and harass and send harassing messages to my client, saying, oh, why are you not home, or why are you getting home at this time? There's a continued pattern. For him being so disabled, he seems to get around quite well when he wants to, and keeping tabs on my client and what's going on the home on 23rd Street. This has not only frustrated any attempts at coming up with a more permanent parenting time solution. My client informs me that Mr. Fierro has not even reached out to her about parenting time. It's always her taking the initial steps, and the parties are right now exercising an every other weekend parenting time schedule. But there's been no attempt by Mr. Fierro to gain more time other than buying through his counsel. I will note to the court that conciliation is scheduled for October 14th in this matter, right around the corner. We would ask that the ex parte order for the exclusive use of the marital home continue. That even though Mr. Fierro may be deemed to be disabled, even disabled people are capable of physical abuse and mental abuse, which has been suffered by my client here. He has a residence that he has been residing in. He has a residence capable of having children at, and he has been exercising parenting time there, including sending pictures and video of the children with him at the residence that he's residing at. There's no need for him to return back to this home. And even if Mr. Fallahy's allegations that my client is the alcoholic, which we deny, why would Mr. Fierro want to return to that environment? He contradicts himself throughout his whole entire objection.
Wouldn't a nesting arrangement alleviate any possibility of physical, emotional, or mental abuse?
What my client's concern is this is just an attempt by Mr. Fierro to continue to exercise control and manipulation. He has an environment in which he has had the children in, has exercised parenting time in. There's no need for him to return back to the marital home. He has been exercising parenting time at his current residence. He's capable of it. The kids have had a good time. I've seen pictures and video where they were smiling and having a good time spending time with their father. And Ms. Fierro isn't out to deny parenting time to Mr. Fierro. She has been willing to offer it. He just keeps on wanting to have more control and manipulate his way into getting back into the home, on the marital home, so he can continue to his pattern of physical abuse or mental abuse, including in some of these messages back and forth that he has had with my client.
All right. I don't like ex parte exclusive use as a mechanism to gain an advantage in a divorce, given that there's significantly disputed facts as to who is the aggressor. I think Mr. Fallahy's request for a nesting order is appropriate. The issue can be addressed at conciliation, and thereafter, if there's still disagreement, the court would consider addressing the issue at an early evidentiary hearing if necessary. But I think the fairest way to do this, to avoid giving either parent an advantage with respect to custody or possession of the marital home, is that a nesting arrangement be implemented. Mr. Fallahy has proposed a joint schedule, either a 5-2, and I can't remember what the other,
The 2-2-3.
2-2-3. Does your client have any preference for one over the other?
I think Mr. Fallahy and I can talk with our respective clients on whether we go with a 223 or a 52, but we understand that is the court's, that's our two options.
Okay, well, that's what I'm going to order. Mr. Fallahy, if you can reach agreement as to what the specific nesting arrangement is, just go ahead and submit your order with that in it.
Thank you, Your Honor. I'll be in touch with Mr. Whiting. We'll get the actual schedule worked out.
Okay, thank you.
Thank you, Mr. Fallahy.
Thank you, Judge.
The other thing I would like to, Mr. Fallahy,
Yeah.
why don't you include in the order a mutual prohibition against harassing, threatening, abusive communications?
How about a standard mutual restraining order?
That works.
I will include that language, Your Honor. Thank you.
Okay, thank you, gentlemen.
Thank you, Your Honor.
Thank you, Judge. I'll call you, Joe.
Okay.
I hadn't asked what pocket I put in. Have a good morning. Too.
All right, you folks were in my waiting room. It's a few minutes before our next hearing time at 10 o'clock. I just wanted to let you know you're welcome to remain in the courtroom, but we are off the record, and I'll be coming back out at 10 o'clock or shortly after to continue my morning docket.
noticed,
What's that?
I just noticed one of the people in on our docket, Wayne Solomon at 10, showed up, and so I clicked the green check mark, and it says he's served now. So I don't know if I did that right, but something happened. He showed up in this wait list, and so I clicked the green check mark, and now he's in this survey.
I think it was just, wasn't it just click the green?
Do you click that when you're done, or when you're, because he wasn't here. So and then I clicked the green check mark, and it brought him
Then
to
no, I think
here.
that's right. I
Okay.
thought that's what she told me. Yeah,
Okay.
I think that's right.
All right.
I am almost positive that's what she told me.
I don't know, maybe it's working?
I have faith in us. I have faith,
I
Peter.
don't know. Me with technology is never great. Mr. Solomon?
Yes, sir.
Feel free to take your mask off inside here.
Okay,
Judge should be back in a little bit.
thank you.
Yep. So when you were downstairs waiting, did your name appear on the TV screen down there?
Yeah, but then it just disappeared, and he didn't know what was going on with that.
Oh, it disappeared? Okay. You didn't get any notification that,
No, and I asked him, he says, just go on up, and if they want to send you back down, they will.
okay, no, you're fine. We're trying to figure out a new system. All rise. You may be seated.
Okay, next up is Solomon versus Solomon. Come on forward, sir.
Yes, sir.
Okay, looks like Ms. Solomon is present. We're waiting for her to make an audio connection. Okay. Ms. Solomon, you can hear me?
I'm sorry, that's not, I'm Diane Negus.
I'm not talking to you.
Okay, thank you.
Ms. Solomon, can you hear? Looks like they're having some technical problems.
Is it on? Okay. Okay.
Okay, Ms. Solomon, can you hear me?
Yes, thank you. Yes, I can.
Okay. All right, and this, Ms. Solomon, is your motion regarding the sale of the vacant land, is that correct?
Yes.
Mr. Solomon, what is the status? Ms. Solomon, you've got some background noise. Can you ask whoever that is to leave the room?
Yes, yes. Okay. Is that better?
I can't hear it now, so that's definitely better.
Okay, thank you.
Okay, Mr. Sullivan, what seems to be the problem with the sale of the real estate?
I'm not sure, Your Honor. It was listed for sale 5.5 weeks ago. We've had a couple offers that were substantially lower than the asking price that the realtor and Melinda agreed upon. And I just wasn't ready to move on 19,000 less on one price and a 15-year land contract on the other.
Were counter offers made? I mean, what came, I'm assuming you got offers on both parcels?
Yes, sir, as one.
I'm sorry, one single offer on both parcels?
Yes, sir.
I see. How do you differentiate between the two parcels?
We got them listed as parcel A and parcel B. One parcel's approximately 8 acres, the other parcel's approximately 9 with a cabin on it.
I remember the cabin.
Me too, sir.
Which one has the cabin?
Parcel B.
B, okay. All right, and the offer that, only one offer was received?
Two. Actually, there was 3 offers received, but she's only got 2 listed in here. There was $100,000 cash offered for both parcels, and it's listed at 148.
Okay, so $100,000 cash for both. Was there a counter offer?
They never got back with me.
Well, I don't understand that. What do you mean they didn't get back with you? They made an offer. When you got, and typically that comes in through the realtor, you get so many days to respond, or you can make a counter offer.
I told Kiera Wilson, the real estate agent initially, that I wasn't willing to entertain anything less than the 148,000 within the first 3 months, because hunting season was coming up, and that will be a high demand piece of real estate for anybody.
So what's it listed at?
148, sir, and there's probably a $15,000 to $25,000 cabin on that we're not going to receive a dime back on, because the property initially was bought for 145 or 148.
Before the cabin?
Yes, sir.
And the cabin was added?
Yes, sir.
And the property was acquired when?
2008 and 2011 possibly.
Are these parcels contiguous?
Pardon me, sir?
Are the two parcels contiguous? Do they touch, do they?
Yes, sir, they do.
Join each other? And they're also near the marital home, correct?
All 3 parcels. The marital home is 16 acres. That's adjacent to parcel A, which is the 8 acres, and that's adjacent to parcel B, which is the furthest parcel to the south.
Okay.
They're all side by side.
All right. So you listed it at 148,000 and you're not willing to accept anything less than 148,000?
Not within a month, sir. This was 9 days later, the first offer came through.
So you didn't even consider making a counter offer?
No. I thought if they were for real and really wanted the piece of property, when they offered me 132,000 plus the 3% concessions, I thought for certainly that they would come back with another offer. But then again, I walked the people through with Kiera Wilson, and we were all talking, and they were talking then that they were only gonna offer so much. And
so the offer was for 132,000?
Yes, sir.
And I don't know, what's the 3% concession?
I'm not sure what that is. That's probably sales fee for the agent. That's all she put in her text, 3% concessions, which
May
works
I
out to be
please?
about.
You'll get a chance, ma'am. I just want
Okay.
to make sure I hear from him
Thank you.
first.
Which the 3% on that 148,000 works out to be about $4,050 if my math is right. I got kids I'm trying to pay for in universities and everything, and it's really hard for me to digest now being double mortgaged and everything, to take anything lower right now out of the gate at the most prime time of the year.
Is there debt on either parcel?
There's outstanding taxes.
Outstanding taxes. Other than taxes?
It's paid off. It's free and clear.
Okay, so we've discussed the cash offer you got. You said there were 3 offers?
That first offer, the 132,000 plus the 3% concessions, that wasn't cash. I don't know what that was.
Oh, I see. So there was 132,000.
135,000 it was.
And they weren't asking you to carry any debt on that?
No, I don't know.
Well, that would have been, I mean, the fact that they're getting a mortgage, you don't care, as long as you're getting cash and
Absolutely,
closing.
absolutely, sir.
Okay. Has there been an appraisal of either parcel?
No, but I suggested this to Kiara Wilson, and she says, I'll check with Melinda. I have an idea what this property is worth because she checked local acreage. And the 148,000 was, it's a pretty nice price for the property with the cabin and the acreage.
Is this wooded acreage, partially wooded, farmland?
There's high woodlands there, there's rolling hills, there's some swamp, there's pine trees, there's about 4 or 5 building parcels.
Okay, so you got an offer for 100,000. You got an offer for 135,000, and you said there was one more offer?
There was a land contract offer.
And what were the terms involved?
10% down, 15 years, 4%.
And how many dollars?
Excuse me, sir?
What was the dollar amount for
They
the
offered
offer?
100,000 cash. No, pardon me. They offered to go the whole 148. They wanted to put 10% down, 14,800, and then they wanted to go 4% over 15-year land contract.
They wanted you to finance, okay. All right, and no other offers have been received?
You got 3 in front of you, sir, right?
3, yes.
Yes. To my knowledge, that's it.
When was the last offer made?
2 or 3 weeks ago.
Okay, Ms. Sullivan, go ahead.
Yes, you know what, alls I'm saying is I would just like him to possibly counter offer because, excuse me, the realtor had asked that we counter offer. I have tried to counter offer with her on every single one of some sort, but since he refuses to do that, it's not, I guess, advantageous for me to do that because he won't. So we have to be both together with this in order to sell it.
Yeah.
She mentioned to me that he refuses to do that. He wants top dollar, which I really don't blame him on that. I really don't. I just don't want to lose the land completely. So I'm just asking that. I'm sorry?
What is the danger of losing the land?
Well, I mean, if it doesn't sell soon, we have more taxes to come up with. I don't have a ton of money. I just don't. So, and I would like to pay off debts with that and get, Mr. Solomon paid off also. and just be free and clear. Um,
Is the property facing a tax forfeiture or tax foreclosure?
I believe in March it will be. So that's why I was just trying to, you know, entertain all these offers. She also had texted us both in a group text, I believe it was yesterday, to see if we would, you know, look at these other two last offers and maybe reconsider and re-talk to these people. I responded, but he had not responded on the group text. Maybe he did it privately. I don't know. I guess.
Mr. Sullivan, you understand that a buyer, when they see a listed price, is always going to want to make, or typically, unless it's a very unique home or something and they're worried that somebody else is going to snap it up. Clearly, that's not the case anymore if it's been on the market as long as it has, and that hasn't happened.
5 weeks, sir.
You see full price offers when property first hits the market. You don't see it when the property's been sitting for sale for a while. The only reason somebody makes a full price offer is when they see it, they're worried somebody else is going to snap it up, and they jump in and they make a full price offer, or sometimes over a full price offer.
Yes, sir, I understand.
And that happens sometimes in a seller's market. If this has been listed for 5.5 weeks already, and the best you've done, an $135,000 offer for a $148,000 listing price, certainly merits some counteroffer. I mean, you don't have to move very much.
Okay.
145,000.
Okay.
I mean, something to sit there and insist on a full price offer when you know now that your property's not going to be snapped up by an aggressive, eager buyer.
How many times do you suggest I counteroffer this? If I go down to 145 and then they're at 135 and then they say 137, how often?
Well, the problem is you don't want to take any less than you can get.
Yes, sir.
And they don't want to pay any more than they have to. And where does that number lie? I don't know. But I would think an offer of $135,000 on a $148,000 listing is not a low ball. I mean, it may be lower than you want, but it's not a low ball offer. The 100,000 was a low ball offer, but this isn't. This is something where you ought to show, you don't have to move very much, but you want to keep them interested.
Okay.
Insisting that you get the list price after it's been sitting on the market for a while isn't realistic.
I went over this with Kiara Wilson and I told her that I was pretty firm on the 148 because Melinda initially wanted it between 165 and 175, and that's why we couldn't get a listing agent previously. So in the meantime, she's changed her marital status. Now she doesn't really, I believe her best interest isn't in getting full price for the property. I believe it's in just getting something out of it as quick as she can.
Well,
no.
And I'm not going to question what her motives are. I'm just looking at the reality of the offer you got based on what you listed it at.
I can come down, sir.
I think that's what you ought to do is throw something back at them to show you're willing to make a little movement to keep them interested in it.
Okay.
Whatever number ultimately the two of you are going to have to agree on, or if I find that you're being unreasonable with what you're insisting on, I can order the sale, and I'd rather give you guys the chance to sell it and maximize your price for it.
I understand that, sir.
And I certainly don't want to see the property jeopardized by being forfeited for non-payment of taxes.
Sir, can we re-look at that, not, the property taxes not being paid?
What do you mean?
You ordered in your divorce judgment that we each pay 50% of the taxes each year.
Okay,
Her part is about $1,500, my part's about $1,600 because I take the bigger one. She hasn't paid any taxes on that, which would only be about $90 a month, maybe to $110 a month. It went into foreclosure and I didn't even know. And I went down to the,
you didn't get notice?
I did, but I went down and paid mine, okay? I got documentation of that.
When you say mine, the two of you
I went-
decided to allocate based on,
There's two pieces of property.
right, A and
I
B.
paid the more expensive piece of property taxes,
Is that the one with the cabin?
yes.
Okay,
And I
but
said-
she didn't pay for A.
And I sent her multiple texts that I have documentation of. She didn't make any effort, and then I told her that it was coming up and it was gonna be foreclosed. She says, I have time, or we have time, I don't remember the text.
So it's the parcel A that's in jeopardy right now?
No, I paid them both off. And
Oh, you did?
the last time, sir, but I had,
To avoid foreclosure?
yes, sir, but I had to go through finagling like you wouldn't believe down there at the clerk's office or the county treasurer's office. She could be paying $90 a month down there every month to help us out. I got kids in college, I got multiple bills. She's not paying child support every month. That's a hell of a burden on me, sir, pardon me.
I get that. Certainly, whoever's paid the taxes gets reimbursed for the taxes upon the sale of the property.
I understand that, sir, but you know what? It's in your judgment that we both pay, and she should be held accountable for that.
I mean, if you have to pay taxes to keep it out of foreclosure, ma'am, you should be reimbursing him for that.
That's what I had said in the beginning of this. That's why I want this sold, so everything can be reimbursed to him. Absolutely. That's what we had said last time when we were on the Zoom call. So, and you had said, yes, Mr. Solomon, you will get your money when the property is sold.
Well, we're looking at another tax bill coming up.
Yes.
He doesn't want to be the one that has to front the money if you're not paying your share.
Absolutely. I understand that. And that's why I'm trying to counter offer and get the property sold at a reasonable price.
Why should he have to front to avoid foreclosure the portion that you should be paying?
I guess that was his choice to do that. I don't have that kind of money. I don't have a job that he has. I don't have a degree like him. So it's a little bit different with what I can make and what he can make.
What you're saying is you didn't pay it because you don't have the money to pay it?
No, I don't have the money to pay a lot of things right now at all.
All right, so Mr. Solomon, I am willing to revisit the issue of you having to front the money if this drags on for much longer. If you have to, if you have an approaching deadline by which taxes have to be paid to avoid forfeiture, well before that deadline, bring it back to my attention and I will address it then.
Yes, sir.
In the meantime, I think you should be making a small concession
Yes, sir, I will.
to keep them interested.
I will, sir.
It doesn't look like it serves either one of you to hold on to this property indefinitely if you're continuing to shell out taxes for it.
That's right, sir. I have another issue with you before you close today.
Go ahead.
come up in front of you, sir, about 6 weeks ago for property taxes, the monies that are gonna be released from the proceeds of the sale of the property, and there was a horse trailer involved. A significant horse trailer, okay?
I vaguely remember a horse trailer.
Okay, sir, you suggested to me that this was no longer a matter that your court could address, that I needed to do it civilly.
Yes,
So I went down and I filed the paperwork. If you'll listen to me for a minute, sir.
I'm listening.
I went down and filed the paperwork. It cost me $165. I missed a day of work. I got a court hearing with Judge Phillip. Is that how you pronounce it, sir?
Yes.
And he was quite perturbed. He swore me and Melinda in, and Melinda told Judge Phillip that you awarded her the horse trailer and the horse tack, and he says, I don't want to hear anything more than this, but it's not my matter. This is supposed to go back to Judge LaFlamme. And in the meantime, I went down to file some more paperwork to re-motion you about that horse trailer because I found it in the divorce agreement. And they said to possibly bring this up to you today like I am right now, and I may not have to do the re-motion. I got the title and the registration for this horse trailer. It's mentioned on page 14, second paragraph of alphabetical letter D. I'm supposed to have the horse trailer. It was taken or stolen from my house. I've contacted her about it. People have pulled it through town. I got liability on that horse trailer. It was full of tack, saddles, about $1,800. I claimed about $1,200 of that. She's not compliant with anything, and it's registered in my name. If there's a pile up in an intersection or a horse gets out or anything, I'm liable for that, sir. And I've contacted the Jackson County Sheriff 3 times about this.
Well, let's back up a minute. The horse trailer was stolen by someone?
I was awarded the house, and I bought her out. Attorney Rapley told me, after you give her the money from the proceeds from the house, she's out, you're in, she can't come back. 5 days after I was in, I was at work one day, and she come over and pulled the horse trailer out of the backyard. And there was movement in the house again for the 3rd or 4th time. This was after she was out from the proceeds of the house. We weren't divorced yet, but the horse trailer was on my property. It's titled in my name.
Jesus Christ.
It was taken from my daughter's personal check for disability. And this is what she bought part of it with, and it's such a long story, it's incredible. But I do have the title and the registration.
Is the horse trailer addressed in the judgment of divorce?
I believe it is, sir. I'm no student of the law, but I can refer you to that section there.
So who has this horse trailer?
She does.
Okay.
I need this money for the kids, sir.
How do I flip it? I don't know. How do I flip that back? Do you know how to flip it? I don't know. Okay. I don't know how to flip it. Participants, I don't know how to flip it. Okay, there.
Does this trailer have a certificate of title?
Yes, sir, I have it right here. I got the registration too.
Peter, would you get that certificate of title? And make of this trailer is a trailette?
Yes, sir. I have pictures of it too, sir.
Ms. Sullivan, you have this trailer?
The trailer actually has been gone since the summer of 2016. And yes, it was awarded to me in the judgment of divorce, along with a lot of other items that I have here, which I really didn't even want to, I don't even want to go here because I want this divorce to be done. It's been 4.5 years.
Where is this trailer?
It is at a friend of mine's home.
Where was this trailer in March of last year?
On Greenwood Road in Grass Lake. Where
At
it
the
has
marital
sat.
home?
No, it has been gone from the marital home from summer of 2016.
Is that accurate?
No, sir.
Yeah.
She lived in that house in the marital home till March of 2018.
No.
Well, where do you say the trailer was in March of 2019?
2019, it was in her possession. She wouldn't give it back. It was going through town and I seen it a couple times and I tried chasing it down and I was at a red light and it was frustrating. I've called the Jackson County Sheriff 3 times about this.
So you got a judgment of divorce that says the parties are awarded the personal property currently in their respective possession with no claim thereto by the other.
Except as provided herein, each party shall retain as their sole and separate property, free and clear, any claim of the other party, their personal property, now or hereafter titled in their respective names or in their respective possession.
But that's where you were supposed to give me the title or sign it over. And since we don't talk or communicate, that never happened.
I've sent her correspondence about this horse trailer, Your Honor.
I have all of your texts.
What's the value of the horse trailer?
$3,800. Would you like to go into the history of how this trailer was?
I think I've gone as deeply as I want to.
Okay.
I'm looking at what does this judgment of divorce provide?
It's titled to me, sir, the way I see it, but I defer to you. She hasn't been compliant when I've told her it's titled to me. I got liability with this home and these kids.
but Blaine, there are things right here. I have a letter, Mr. Rapley, when you locked me out of the house when I had 3 days left to get the rest of my belongings that were in the judgment, like the treadmill, 2 diamond cabinets, dresser, the TV cabinet in the basement. I have so many things, yet I don't want them because I want this divorce to be over. I want us to be over. Please.
You've taken every family heirloom,
Nope,
everything these
I
kids
have
ever
not.
had coming. It's
I
in
have
the
not.
court papers. It's in the court papers.
No,
You're gonna
it is
deny
not.
until the end of the earth. We'll let the,
Yes,
Your Honor decide.
yes, I will deny,
I need,
and I do not.
I need,
have it.
I need you both to be quiet while I read this. The language, frankly, is contradictory. So we've got the first part of this personal property provision on page 14. The parties are awarded the personal property currently in their respective possession with no claim by the other. And clearly, the trailer and whatever was in the trailer was in her possession on the date of this judgment. And then when we go to that next subparagraph, it says, except as provided herein, each party shall retain as their sole separate property, free and clear of any claim of the other, the personal property now or hereafter titled in their respective names. Well, that exception clause means that the first clause governs.
Okay. Thank you, sir.
I don't know any other way to interpret that, sir.
She took this check from my daughter.
This has been discussed. We've been
And the
divorced.
Jackson County
Blaine.
Sheriff came
Stop.
out that day.
Hold on, but well before the judgment of divorce was entered.
Yes, sir.
So whatever happened before the judgment of divorce was entered,
Okay,
doesn't matter.
all right.
I have to enforce the judgment of divorce. That's what it says. Okay, so you're going to entertain, or you're going to make some kind of counteroffer to this offer that you've received?
What should I offer, sir?
Well, talk to the realtor, get their advice.
How
I
many
realize,
times- How many times do I have to counteroffer?
well, as long as they're moving and making significant movement, getting close enough, what you don't want to do is hold on to this property for 2 more years, have to pay more taxes on it, and get farther behind.
Yes, sir.
I mean, you need funds based on what you're telling me. I would at least make a 145,000
Okay,
and see what they do.
okay.
I mean, the fact that they made 135,000 is a significant offer. It's not a low ball. It is,
There's 4% concessions on that as well, sir. So that adds up to be about 139 then. So that's like 40,000 off the top.
well, then counter the concession. Whatever it takes to drop your price a little and try to figure out and probe how much they're willing to do. That's the only way you can do it. I'm not going to tell you have to counter at any particular.
I'll work with the court.
And listen to your realtor. I mean, they're the ones that know this stuff.
Yes, sir.
All right. Well, good luck. I hope you're successful.
Thank you.
Thank you.
You're welcome, ma'am. Oh, sure. You're going to want this back.
All set then?
Yes.
Okay, thank you so much. Take care. Bye-bye.
Okay, I'm gonna let everybody in because it's hard for me to tell who's who. So once I do that, I'll call the next case.
Hello?
I would ask you.
Hello?
Yes. Yeah, listen, okay? I would ask all of you to please keep quiet unless I've called your case. I've let a lot of people into the courtroom Zoom room, and it's hard for me to do this if you're speaking out of turn. Okay, the next case I have up is Bacon versus Bacon. Is anyone present on that case? Okay, doesn't sound like it.
Hello?
Yes? What's your name?
Sienna Storm.
All right, that's not the case I just called. I'm gonna call the name of a case, and if you're present on that case, speak up. If you're not on that case, please don't speak. Okay?
Okay.
All right, next case up is Smith versus Snyder. Is anyone present on that case?
You have orders in those files, or do you need me to do that?
I have orders so far. Next case up is Gates versus Negus.
I'm here.
Okay. State your name, please.
John Gates.
Okay. And I heard someone else speak. Is Diane Negus present? All right. So, Mr. Gates, you're here asking the court to issue a personal protection order against Diane Negus. Is that correct?
Yes, sir. And she, for the record, sir, she is on the video. I just think she's muted.
Oh, okay. You can see her?
Yes, she's in the burgundy or red shirt.
I
Oh,
apologize.
okay.
Can you hear me now?
I can. Hold on just a
Okay.
minute.
I've never used Zoom before. I apologize.
No problem. Okay, so Mr. Gates, I need to take some testimony from you.
Yes, sir.
When I'm done hearing testimony from you, then I'll hear from Ms. Negus, okay?
Okay.
Okay, Mr. Gates, would you please raise your right hand? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your full name for the record.
John Richard Gates, Jr.
Mr. Gates, what is your relationship with Ms. Negus?
Is my ex-wife.
She is your ex-wife, is that what you said?
Yes, sir.
Why do you believe you need a personal protection order against her?
Well, this has been progressing over the last 2 years. I guess finally coming to a head this past summer, but continuing unprovoked, harassing text messages, derogatory, threatening in nature, and I guess it finally came to a head in July when she had an issue with my work schedule and called me at 10:30 at night and began yelling and screaming at me. She is, in that call and on others, has threatened to come to the house and not only assault me, but assault my wife. She's in August, there was an incident where our son had an open house at the school, and it was set up so that the teachers were outside on the sidewalk, and you had to drive through and make contact with them. Asked to ride in the vehicle with myself, my wife, our son, and my stepdaughter, and I told her no based on her behaviors. I don't trust her outbursts, and I don't trust that she can conduct herself
Let me,
appropriately. So,
Mr. Gates, let me stop you for a minute.
Yeah.
Because you broke up just a little bit. Something happened on school property while you were in your vehicle, correct?
yes, sir. It was an open house.
What did she do?
Specifically at the school, nothing happened other than her getting upset that she wasn't allowed to ride in the vehicle with us for the open house. And then she sent me a text message saying that she would be waiting at our house. When I told her we weren't going to the house and that I was actually dropping my son off at my mom's so he could spend time with her before school started, she then came over there and initiated an altercation. She blocked us in the driveway and came yelling and screaming up the driveway at us in my mom's driveway. She came at me with her fist raised like she was going to assault me. And then when I took a step back, she then got in my wife's face, yelling and screaming at her. We got into our vehicle, locked the doors. She came up to the passenger side door, tried yanking the passenger side door open where my wife was sitting.
I didn't.
And during all of this,
I didn't touch your
my
truck.
5-year-old stepdaughter was.
Hold on a second. Ms. Negus, you have to be quiet until it's your turn.
I apologize.
My 5-year-old stepdaughter was in the back seat of the vehicle crying because she was so scared at Diane's behavior. We asked her to leave. She refused to leave, so I called Blackman Township to file a complaint. She ultimately left just a few minutes before Blackman arrived. There were numerous text messages after that. And then on September 15th, she got notice from my attorney that I had filed the edge row that you ordered on her behalf because for the last 2 years, she's refused to do it, which hasn't allowed me to make any changes to my retirement plan regarding beneficiaries. That upset her. So during the course of the conversation, once again, she started screaming at me and she said, and I apologize for my language, sir, but she says, "It's fucking funny, John. I ought to fucking kill you." And then at the end of that conversation, she says, "You're going to push me to the point of no return. And if anything happens to me, tell my son that I love him." So 2 days later, I get another phone call from her and she says, "John, I'm going to fucking kill you one of these days because you keep fucking with me. Watch your fucking back and your fucking whore too," referring to my wife. And then she just, she cut off because she was screaming and just crying so incoherently. I do have recordings of both of those phone calls. But this behavior has just been progressively getting more and more uncontrollable. Her anger and her outbursts are to the point where I'm not sure what she's capable of, sir. I'm concerned about her showing up at my house. I'm concerned about her when I have to drop him off at her house, she seems to be more and more reliant upon our son for her emotional well-being. Every time that she feels I'm threatening her ability to become a mother or to be a full-time mother or whatever, she gets angry and she has outbursts. And I don't know what she's capable of. She states that she doesn't talk to anybody, that she just stays home. But yet she's telling me that everybody she talks to agrees that she's in the right. I've got almost 600 pages of text messages where it's just a repeated and continued harassment and abusive language that I don't want. All I want is to be able to co-parent. I want to exercise my parenting time without harassment and without being told that I'm interfering with her time with our son.
So, Mr. Gates, you have one child in common with Ms. Negus?
Yes, I do, sir.
What's your son's name?
Jameson, Jameson.
And how old is Jameson?
He is 6 now.
What's the custody and parenting time arrangement?
We have joint physical and legal. I have him from Sunday night at 6:30 p.m. until Wednesday night at 6:30, and then I have him for 3 hours after school on Thursday, so from roughly 3:30 to 6:30.
And how are exchanges done?
Typically, I pick him up and drop him off with the exception of Wednesdays, and she comes and picks him up on Wednesday afternoon, or Wednesday evening, I guess, from my residence.
Any reason exchanges couldn't be done with each parent remaining either in their car or in their home, depending on where the drop is?
That is what we've gone to. She doesn't get out of her vehicle at my house, and I park at the very end of her driveway and don't get out of my vehicle. In early May, she requested that we do exchanges at Blackman. I suggested in August that we do exchanges at the state police parking lot, and she adamantly refused that.
Is there, assuming each parent remains in their home or vehicle at the time of exchanges, there shouldn't be any opportunity for confrontation, correct?
There shouldn't be. However, she comes out of her house, she comes out of her garage.
My assumption, sure, my question was, assuming each parent remains either in their car or in their vehicle, there shouldn't be any opportunity for conflict during exchanges, correct?
That is correct. There shouldn't be.
Okay, so if she doesn't remain in her home or in her vehicle, obviously, there is the opportunity.
Correct.
But if each of you stays that far away, then, I mean, I can certainly enter an order that says that. And if either violates, then there's a potential for being held in contempt of court. Has she ever been physically violent towards you?
Other than the incident at my mom's where she came at me, there was nothing prior to that, no.
You said she's made a couple of threats to kill you.
Yes, sir.
Do you know if she has any ability to follow through on such a threat?
She owns firearms. So, and with her, the way that her anger has progressed, sir, that's why I have the concerns. She seems less and less able to control that anger and hostility.
All right, let me hear from Ms. Negus now. Ms. Negus, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your full name.
Diane Marie Negus.
Okay, Ms. Negus, you've heard the testimony from Mr. Gates. Do you dispute any of the information he provided?
I do. Mr. Gates is not the good guy that he would like everyone to believe he is. This wife that he refers to is his mistress. And after we split up, I started digging around and I realized that for the better part of our 7-year relationship and our marriage, that he was unfaithful. He cheated on me so many times. I've read messages, seen pictures of him naked on our son's first Christmas, sending naked pictures to female friends that he was sleeping. I mean, it was just disgusting. So yes, I'm sorry.
Let me stop you. What I'm interested in hearing about is anything that he testified to.
Yes.
That you disagree with.
Yes, because he makes it sound as if. May I speak, please?
I don't want to go into a background of.
But he makes it seem as though my
anything-
text messages to him are unprovoked, and they're not. He treated me like garbage for 7 years and I had no idea. So I'm not always nice to him. No. And I don't have to be. But John can't separate my being mean to him because of what he did to me throughout our marriage and our relationship from our co-parenting relationship. And that's not fair to me. I don't have to like you and I don't have to like your wife or your mistress, but we can still sit in the same vehicle and meet my 6-year-old's teacher. Just like we had a mutual birthday party for him last year together at Chuck E. Cheese. I mean, I can separate the two. I don't understand why he can't.
So he described an incident that occurred where you came over to his mother's house.
I left the school and went to.
And came at the car. I don't have all of the.
Right.
Let me see what he said. I mean, do you acknowledge going to the house, his mother's house that day?
Yes, sir. We were at the school and I asked him if I could get in his vehicle to go through the open house to meet Jameson's teacher. And he told me no. I tried to go through the line in my vehicle. It was very hectic and chaotic anyway. And I was making it worse. The teachers, I didn't know where I was going. We tried to be on a FaceTime conversation so that we could all both hear. They were talking to her teacher. I don't know who they were talking to, but I asked a staff member if I could please get out of my vehicle and stand by his truck. I'm sorry. And I was told no. And so I pulled my car over out of the line so that I wasn't in the way. I again tried to, at that point, our FaceTime conversation had been disconnected. So I again tried to reconnect, but it was too difficult to try to decipher who was talking to whom. And so I left. And I went to John's house because I wanted to talk to him. He makes it sound like I went there unprovoked. No, I missed my son's kindergarten open house. And I wanted to know why he did that to me. What was his reason? So when he responded and said he was going to his mom's, his mom and I were on good terms. I've been to his mom's house plenty. It's not like I wasn't welcome there and just showed up. So yes, I went to his mom's. Now, the entire time that we were talking, I thought his 5-year-old stepdaughter was in the house with Jameson. I thought I heard her in there. And at no time did they tell me she was in the truck. And later on, when they did tell me she was in the vehicle, I felt awful. And I apologized over and over. And I would never, ever try to scare her, or, that's not, these kids are innocent. I don't, that's not my intent. But yes, I did go because I wanted to talk to him. This last year, he's been using Jameson, he to hurt me. And that is not okay with me. And that is what makes me so upset.
Do you acknowledge that you made threats to him?
I don't remember exactly what I said. I was so upset. John has been so cold to me since I had no idea what was going on. And the whole thing has caught me off guard. I don't recall exactly what was said, but I know that I have been extremely mean to him. I have been vulgar to him. I have been hurt. And I've responded by being, for 7 years, we never fought. We never had a disagreement. And to find out that entire time of my life was a lie, the best years of so many memories ruined. I treat him with the amount of respect that I feel he deserves. And so I do say mean things. I do text him late at night. He works third shift, so I know he's awake on those nights. If I'm up and but I am not a threat to him. He knows. And if I would have known that he was recording our conversations or wearing a body cam when he came, I would have known. If I would have thought that he was ever going to take anything to this level, I would have pulled back a long time ago. I am mean to him because he deserves it for what he did to me. And him to use Jameson to hurt me is not okay. But I don't deserve this PPO. I don't deserve to be in my house without a way of protecting myself and my son. He's being dramatic. He's far from a victim in any of this. And this is the only opportunity he's had. I gave him a perfect opportunity to play the victim, and now he is trying to run with it. He's far from a victim, and I hope you can see that.
All right. After listening to both of you, I think the best thing that I can do in this case is issue not a personal protection order, but instead a restraining order in your custody file. That restraining order will prohibit you from threatening, harassing. It'll require both of you to stay either in your vehicle or in your home, depending on where exchanges take place. And it's certainly punishable by the contempt power of the court. Ma'am, I appreciate why you feel angry. You have no right to display that anger to Mr. Gates.
He kept
If you
me
want to
from my
be
son
angry,
on my son's 6th birthday. I didn't even get to see my baby on his birthday.
if you want to be angry, you can choose to be angry, but you cannot vent that anger at Mr. Gates. I will make I can't do a mutual personal protection order, but I can do a mutual restraining order in your custody file that will provide Mr. Gates from further incidents of harassment. You'll both get a copy of that.
Yes, sir. Thank you. Can I still have my firearms in my house so I can feel, or is that?
Based on the testimony I've heard today, I believe you made threats. I don't see you as actually carrying out those threats, so I'm not going to restrict your ownership of firearms.
Thank you.
Your Honor.
Thank you both. You'll be getting an order from me.
Your Honor, can I ask one question real quick first?
Sure.
And I asked that my wife be included in that Diane not be allowed to send her harassing and threatening messages as well.
Yes. Yeah, what's her name?
Her name is Haley, Haley Gates.
Spell it again. Haley?
Yes, sir.
Yes, I can include that.
Thank you, sir.
All right, thank you.
But that's fine. I have no problem. Thank you so much.
I will need a denial, yes.
I'll do that right now.
Snyder and Smith are here. Snyder and Smith are here.
Okay, next matter up is Ellis versus Ellis.
Come on. Hear me. Here.
And I'm sorry, state your name.
It's Brandy. It's now Steph.
Okay, hold on. And I'm sorry, what is your last name now?
It's Stepp, Stepp.
Okay, and is Russell Ellis present? Hold on, I got some more people out in the waiting room. I'm gonna let them in.
Okay.
Hear me, sir?
Come on.
Yes. What's your name?
Is somebody talking to me about name?
I see Russell's iPhone. Is this Russell Ellis?
Yes, sir, it is. Can you hear me?
Barely. Can you turn up your volume just a little bit?
Yes, sir, I'm trying. Okay, let me see this. Okay. Can you hear me now?
I can hear you. Ms. Stepp, can you hear him?
Yes.
Good.
Okay. All right, give me just a moment. This is Ms. Stepp's motion regarding parenting time. You're asking that the court suspend Mr. Ellis's parenting time and require him to submit to a psychological evaluation?
That is correct. Wow.
Why do you believe that's necessary?
Well, Your Honor, it's been 4 years since you've had our case. I've been back to court a couple times with TPOs. Let's start for the last 2 years. It has been a couple times that he's had overnights, mainly with my youngest, my 12-year-old, Kenneth. He was in jail for a little bit, got out in July 2019. A lot of problems happen when he's around. My youngest, my 12-year-old, he is very severely affected emotionally. He has a lot of influence from his father on him when he does have parenting time with him. I believe that it's detrimental to him in the long run. He is showing a lot of behaviors that are similar to his dad's. I can give you some examples of why I believe he needs a psychological evaluation. A lot of it stemming from, again, the last time that you had granted me custody of all 4 of my children. Since then, it has been a journey. It has been a good journey, a good learning journey, but a lot of problems, again, stems from behaviors of his father and the influences he has on his children. Kenneth has shown recently some similar behaviors of his dad. He most recently has been having some issues with school. He's been arguing over the fact that his dad was emancipated when he was 15 and he believes he should not have to go to school. He has shown behavior of taking advantage of people, trying to dicker and deal with people in the same manner as his father has done many times in the past with our own possessions, such as TVs, game systems, even taking back presents, Christmas presents, and stuff like that. Again, the same behavior Kenneth is showing. When Kenneth doesn't get his way, again, this is my 12-year-old, he doesn't take no for an answer. He will be borderline harassing you. Again, this is examples of his dad's behavior, which again stems from not only his dad, but his father, his dad's father, so his grandfather. I let my son have a relationship with his grandfather, found out, I mean, pretty much not too long down the road that the behaviors were passed down from grandfather to son, and now those influences are being strongly pushed on to my son, who I've had in counseling since February with the community mental health in Lansing. And they feel the same way. There's some influences and behaviors that are similar and the same of his father. I had a lot of issues in the past with manipulation, degrading, his father treating me very poorly in front of all the kids. And again, this behavior stems down to my son. I've had behavior issues with him with females, not treating them with respect. Most recently, the reason I'm bringing this up is again because every time he is involved with parenting time with his dad, I see it when he comes back to the house. The effects are very, very strong. This last time well, first of all, we have a PTO that he's not supposed to even be communicating through the children. I got a text message from my son's phone, Russell. He's not a junior, but it is our son. And Big Russ had texted me through his phone asking if he could have him one of the weekends on the 24th of September. I did not respond. And then I later got another text message on September 28th asking if he could take him for Labor Day weekend. I then denied him. I told him that I had plans with him. And that Friday for Labor Day weekend, I got a phone call message, a voicemail because I was at work, I didn't answer my phone. I listened to the voicemail. It was at 8:30 in the morning stating Russell Ellis, my ex, had my son and he was taking him up north because it's his weekend and he's exercising his parenting time, and that I had denied him twice, and therefore by default he is entitled to have him. Well, that's not all correct because I only denied him the one which was Labor Day weekend.
Ms. Stepp, I don't have this much time this morning. You're asking me, well, I've got to move this along. So has Mr. Ellis been exercising parenting time with
No, he's not.
With all three children?
No, he's done it behind my back. He has had parenting time with Kenneth for 2 overnights in the last 2 years. And this last time was behind my back, and he plotted this with my son. So he's showing him behavior that it's okay to go behind his mother's back. It's okay to do this.
What about Christian? Has he been exercising parenting time with Christian?
Christian doesn't want anything to do with him. He hasn't seen him in 2 years.
Okay, so the only issue here is Kenneth.
Yes, and his dad's influence, it's detrimental in the long run, and it's going to be very
I understand that, ma'am. Ma'am, I understand that. And Mr. Ellis, you would wish to be able to continue to exercise your parenting time with Kenneth?
Yes, no, sir. That's actually I wanna, and I would like to have my parenting time with all my children. And I just heard you say, Your Honor, I understand you guys don't have the time for this morning, and this is something, all the evidence I have 12 CPS cases against her. I have 36 police reports. My son is expelled for the last year and a half from Leslie schools. I have no less than 80 reports from the school. I recently I've obtained a lawyer from Adam, attorneys for divorced men. So at this time, I would like to see if we can set up a court date. At that time, I will come down with my lawyer and with all the evidence. But, sir, I have not talked to my ex wife in over a year. I have talked to her twice or several times via text, asking her if I can exercise my right to have my children. She got upset because we went up north Labor Day weekend, me and my family. My dad rented a cab and we went fishing for 3 days. I talked to the police. I did it the proper way. I contacted the Ingham County Sheriff's Department. They came out, met me, and they said, "Sir, enjoy your weekend with your kid." They're at her house every other day. They're very aware of the situation. And, we had an appointment the other day in front of a referee. And the first thing she tells the referee is, "Ma'am, whenever we have a court date, my ex-husband gets off the phone and calls all the kids and brings them all in on it. I want this to stop." So, after the court date the other day, I made, I got a concern. Since my daughter's been 16 years old, my ex-wife, allows her 20-year-old boyfriend to stay there, and my daughter is allowed to stay at his house. I had a problem with that. And this is what all this is coming from. And right after the court date last week, I have all the text messages. I recorded the calls. My daughter called me flipping out. Why would you tell the court staff? You know what I mean? She instantly got on the phone, called my kids, tried to turn them against me. Your Honor, I've not missed a child support payment over a year. I work hard. I go to college full time. I'm in the apprenticeship program. I have never threatened her. I don't even speak with her, Your Honor. And she has not allowed me to see my children. Like I said, I have all the evidence. I've been very smart. My lawyers told me to do everything. I've recorded everything, every call.
So you're telling me, let me stop you, that your attorney is getting ready to file some kind of a motion on your behalf?
Yes, we're going back for custody, full physical custody, absolutely.
All right, so here's what I'm going to do. Here's what I'm going to do, Ms. Stepp. At such time as Mr. Ellis files a motion for custody or to change parenting time, I will consider the merits of your motion. I'm not going to grant any relief today. If that happens, we will address all of the issues of custody and parenting time when that motion is filed.
Thank you, sir. And sir, why I have both of you right here, so you're a witness, could she just tell me she can even pick the weekend this month? What weekend can I have my kids, just so you're a witness? Because for over a year, she has not allowed me one weekend. I got to go behind her back. That or I have to go down there like I did Labor Day weekend and pick my kids up. And see, here's the thing, Your Honor. I got all the messages. She allows Haley to come up, but she won't allow my youngest son. It's because her husband doesn't like me. We got into an altercation, which the courts are well aware of, a couple years ago. He has
All right, let me stop you.
Sure.
Ms. Stepp, can you identify a weekend this month?
Oh, boy.
I want all three kids too, Your Honor, what I'm entitled to. I want Christian, Haley, and Kenneth. Those are my three children.
What weekend, ma'am?
Christian's not going to go with him. I can tell you right now. And you're just you're going to base my children going with this man on
what weekend, ma'am?
This is not fair. This is not fair at all.
All right, which weekend would you like, Mr. Ellis?
I would like this weekend, Your Honor, if that would be good. I have some plans for fishing trip before the cold weather sets in. And I talk to my kids every day. They call me. I talked to them last night, and I'd mentioned the fishing trip to Kenneth and everything, and he's looking forward to it. And I'd like to do it this weekend. I haven't been able to. And Your Honor, we're supposed to alternate every other holidays. She won't give me a holiday in 2 years.
Yeah, I don't want you having this.
You need to file your motion, sir, but we'll say this coming weekend is the weekend for this month.
Thank you.
And I don't have it.
That concludes our hearing. Thank you.
Hey, thank you.
All right, court needs to take a very short break, and then I'll get back out and try to move through the rest of the docket.
Snyder and Smith have been here.
Yep, I was just about to.
I
finish
can't.
my-
What the?
Do you have the Gates and Negus file? Because I did an order for that. It was a PPO. Maybe he gave it to me. Nope, I got it. I got it. And he'll end up probably just giving it to Dawn.
Okay.
I just want to get a plug really quick. My office. Yeah, I know.
Can anyone hear me? Can anyone hear me?
I can
Man.
hear you.
Who's me?
I'm waiting for my case to be called and I can hear you.
You. I've been trying to talk to the judge for 20 minutes and I can't get his attention. They called our case the second one and I can't get through.
I would try to catch him again after recess.
Okay. Shit, I'm at work sitting in the car. I've been here for an hour and a half.
Same here, same here.
Man. Fucking bullshit anyway. I got 39% charged. And I haven't even seen the judge yet. And my charger won't work. What kind of charger you got? I don't know what that is. Oh my goodness.
Oh, sorry. Thank you. Come on, baby.
For taking temperature. Normal temperature.
You gonna see me in a few minutes. I'm running in and out today.
Okay, let's see, next up.
Snyder and Smith are here.
Hatch versus Dan.
Oh my
Yes, Your Honor.
God.
Is anyone present on this matter?
Yes, Your Honor. Sloan Hatch here. Can you hear me?
I can.
Okay.
This is Miss Sloan.
Yes, it is.
Okay, and is Mr. Dan present? David Dan? Okay, so. Ma'am, you're asking the court to hold a review hearing concerning modification of your parenting plan?
Yes, Your Honor. I'm having a hard time kind of hearing you, the background noise, but I'm trying to listen.
Yeah, I was trying to figure out where that background noise was coming from.
Yeah.
Just a moment. I see somebody else has signed in. Let me see who that is.
I'm sorry.
Okay.
Hello. Can you hear me? Can you hear me, sir?
Yes. Who is this?
This is David Dan. I've been on the phone the whole time, but I think I've been put on mute or something. I couldn't get off of it. So I just called back.
We can hear you now.
Thank God.
Okay. So Ms. Sloan is present. She's asking the court to modify the parenting time. She's been exercising, it looks like supervised visits with the friend of the court Family Visitation Center. And she would like to expand that time. What is your position on that?
Well, Your Honor, I'm going to kind of read from her paper so I can make it faster so I'm not bouncing around and trying to fumble for words. I'd just like to start out by saying the Parenting Center has been great to us, even contacting us during COVID, which was devastating to me in London. Me and my daughter still have a great bond that, we've always had, and it's been wonderful. It's been great. It's been hard dealing with, David not being able to, no Christmas presents, no birthday presents, things like coats and hats. But I've missed 5 visits, I think it was.
Ma'am, let me stop you. I understand you're looking for more parenting time. I just asked Mr. Dan what his position was on that. Let me hear from him.
Okay. Well, Your Honor, I just filed a motion about a month ago, maybe a month and a half now. But ever since then, the first day after that, she called in, and then the week after that, she called in. So she called in the first 2 weeks after you granted her to be able to keep seeing her. And
Your Honor, I have liver damage, and I do have documentation of me being in the hospital sick. When my liver gets sick, it just happens. I can't say when it's going to do. I did see a liver specialist last week, and they are putting me on a pill to cure my liver. So I am doing what I'm supposed to be doing medically. I was in the hospital and almost died 2 times. So it's been very.
Mr. Dan, you're opposing any modification because you're saying that Ms. Sloan has not availed herself of all the time that she's already been allotted. Is that accurate?
Yeah, exactly.
I've missed 5 visits out of 22 visits due to liver damage.
Ms. Sloan, I understand. Your position is the visits you missed were for a good cause because of your health issues.
Yes, Your Honor.
All right. So we've been doing family visits, supervised visits for some time. Mr. Dan, what do you oppose moving to unsupervised visits?
Yeah, I'm very opposed to that, especially after last year. She got pulled over drinking and driving with, crack pipes in the car. And
it was more than a year. It's not
December,
a crack pipe. That's not true.
Ma'am, don't interrupt.
And just last December, she had a court case with her other daughter, Mariah, and she was supposed to go down and take a drug test right afterwards, but she just bailed. So now she's not even allowed to see her other daughter, Mariah, because due to not following through what that judge ordered her to do.
Only because there were lies, people coming to the court that didn't even know me. It was devastating to me, and I went right to Lifeways afterwards. I have documentation of that also. And as soon as I get back from German Island, I can do drug drops every time before I get her.
All right. Well, clearly there's factual disputes here. The only way those can be resolved is by taking testimony. I'll schedule the matter for an evidentiary hearing on parenting time. You'll both get notices. Please make sure that you have any witnesses present, and that would include, Mr. Dan, any information you've got about the other custody file. We'll set the matter for an evidentiary hearing.
Okay, thank you.
Okay, thank you very much.
All right.
Are you still there, Your Honor?
I am, but I'm done with your case.
All right. That's what I thought. All right. Well, thank you very much. All right. Bye-bye.
Okay. Next up is Storm versus Storm.
I'm here.
Okay. You are Stevenson Storm, correct? Did you hear me?
Yes, I can hear you. Can you hear me?
Oh, yeah.
Yes.
I just asked you a question and I didn't get a response, so I was.
Yes.
You
I
are
say yes.
Stevenson? Okay, well, we didn't hear that. Okay, and let's see, do we have Shauna Storm present? Doesn't appear that we do. Give me a moment to look at my notes here. Ah, yeah, I remember reading about this one yesterday. So, Ms. Storm had a paternity test done that has eliminated you as the biological father of Sheila. You acknowledge that?
Yes, my honor.
Okay, hold on a minute. I see another phone in there. Let me see if that's her. I just let an iPhone in. What is your name, please?
My name?
No.
Okay.
I just let somebody into my courtroom on an iPhone. Ma'am, what is your name? With the blonde hair, I cannot hear you.
Me?
Nope.
Me?
No, I see. We're making a connection. Okay. I just let you in on an iPhone. What is your name?
Sienna Storm.
Okay, good. Now I got you both here.
Sorry, it
All
kicked
right.
me out of the meeting for some reason.
Well, you're back in.
Okay.
All right. According to what I read in the file, even though Sheila was born during your marriage to Mr. Storm, you've subsequently learned that Sheila has a different biological father, correct?
Correct.
Wow. And Mr. Storm, do you acknowledge that?
Yes.
All right. And what Ms. Storm is seeking to do is have me determine that Sheila is not a child of this marriage and to have you removed as his father from his birth certificate. Is that something that you oppose?
Yes, that's what I want to do.
That you want that to happen as well?
Yeah, it's both
All right.
of us.
Okay, so what I need to do is schedule this for a time when I can receive testimony from both of you. Ma'am, technically under the law, you're supposed to file a motion with an affidavit. And in the affidavit, you're supposed to set forth facts from which the court could essentially modify the judgment of divorce and make a determination that your child, Sheila, is not Mr. Storm's child. So I cannot do that this morning. You need to file that affidavit. And an affidavit is simply a statement that you make under oath. So it has to be verified by a notary public. Once you file that motion, I will schedule the matter for an evidentiary hearing. I'll take testimony from you and from Mr. Storm, and if necessary, from the person you believe is the biological father, although that's not crucial. The important thing is I get your testimony, ma'am. There's a specific statute in Michigan that governs this kind of thing. Do you have a way to make a note of the statute, ma'am?
Yeah, I can make it write a note.
Okay, it's Michigan compiled law 722.1443. The affidavit has to meet the requirements of subsection 12 of that statute. You should be able to find it online. Look it up. Make sure your affidavit includes the information required here. And then at that point, I can schedule a time to take some testimony. And we should be able to accomplish this for both of you. I will get you a date. We'll send it to you in the mail. Let me make sure. Mr. Storm, I've got an address for you in Sioux Falls, South Dakota.
Yes.
Is that accurate?
That's accurate.
And ma'am, I've got an address for you in Imlay City.
Correct.
Okay. Did either of you have any questions for me?
Yes, I do. I've actually the child since 2019 the child is not mine, so I thought that maybe they should hold the child support because I cannot keep paying something that's money where like the kid is not mine and the child doesn't even know who I am. So
if I grant this motion, it will terminate your child support obligation.
Okay.
All right, you'll be getting a notice in the very near future.
Okay, thank you.
Thank you.
You're welcome. Have a good day.
You too. Bye.
Yeah. Oh, man.
Okay, next up is Downard versus Gilman. Is anyone present on that matter?
I am, Your Honor.
Tasha Downard is present, Shannon?
Thank you.
And it looks like
Evelyn Calagero for
Kevin
Kevin Gilman.
Gilman is present, as well as
Yes, I
Ms. McCluskey. And Mrs. Calagero.
Yes, sir. I'm here.
All right, okay, we've got everyone here. So last week, I directed that we adjourn this for a week to give Ms. McCluskey an opportunity to talk to Taylor. Did you have an opportunity to do that, Ms. McCluskey?
I did, Your Honor. So as a quick update, I spoke to Taylor. My opinion still hasn't changed. My recommendation still hasn't changed. I think he's ready for visits with mom. It sounds like the calls did go well. He did take it upon himself, as we discussed last time, to schedule a meeting with his mom, and then apparently was notified by Mr. Gilman and his wife that he had plans after the fact, and we discussed this last week. I still am unsure why a 15-year-old or 16-year-old wouldn't know why he had plans beforehand. So I thought that was a little strange, but whatever the circumstances were. So my discussion with Taylor, I did confirm that he was alone. He apparently stepped out of the house to speak with me. And I just want to reiterate again, I've never had any suspicion that Mr. Gilman is trying to frustrate this process. He seems to be very cooperative with me, but I did find it odd that at some point Mr. Gilman took the phone from Taylor. It didn't announce that it was him. I just had to figure out somebody else had taken the phone and kind of butted into the conversation. And it was, he said he was passing by to get the mail, and that's fine. But I think that type of stuff really is harming this procedure here. But so when I spoke with Taylor, I do feel like he kind of reignited these requests for documentation that I still don't think is originating from him. So I almost felt like he had been spoken to by an adult and he was kind of going in reverse, but then upon kind of further conversation some questioning, he was kind of back to where I have always found him to be very receptive and open to contact with his mom. So again, I don't have any concern. I know Miss Calogero and Miss Downard shared some emails back and forth and were very good they seem to be kind of working out some sort of agreement as to contact and time and scheduling and all of that stuff. And I know they made some progress there. I'll let them speak to that. But Taylor, again, still seems open to contact with mom. And I mean contact, I mean in-person visits. And I think Miss Downard would be very healthy at this point for Taylor. So thank you.
Do you have a specific contact and visitation schedule that you're recommending?
Not necessarily. I think because, and I know the court indicated, and I agree that it's probably best that Mr. Gilman and Ms. Downard communicate directly and not have any third parties, or maybe through the attorneys. I don't care, but I would say I would leave that up to Taylor. I would like to see once a week, once every other week at least to begin with. Taylor's 16. I don't think anyone's going to start forcing him into overnights or weekends if he's not comfortable, but I do honestly feel like he may be comfortable. So honestly, I would leave the schedule up to the parties and to Taylor because of Taylor's age, but I would like to see it be regular. I think this has gone on far too long, and I believe Taylor's ready for a relationship with his mother.
Good.
And Ms. Calogero, are you advocating for a specific schedule?
Yes, Your Honor. The Gilmans proposed a schedule to me that I sent over to Ms. Downard. Now, Ms. Downard said she was okay with the phone call schedule. That would be that Taylor would call her every Monday and Thursday between 4 and 5 p.m. That he would be allowed to call whatever other times he wants, but the Thursday and Monday would be mandatory to develop a better relationship between the two of them. If he doesn't want to talk, he doesn't have to talk. Conversations will only be about what Taylor feels like talking about. Tasha can email if there's something important that Taylor would need to know on the other days, so that they can have Taylor contact her, and neither parent will talk bad about the other parent. That was the first set of conditions for the phone calls. Now, the visits, she is not, she doesn't want to leave the visits up to Taylor. And I know during our first status conference, you indicated that Taylor is old enough to state when he would like to visit. So at some point, Taylor needs to be able to say, yes, I'd like to visit this week. And if you'll remember, Mr. Gilman works 10 days on and then has 4 days off. And if Ms. Downard is objecting to Mrs. Gilman transporting Taylor, as opposed to Ms. Downard coming and picking him up, then those visits have to be scheduled on a day when Mr. Gilman is off of work. And that would be like every 2 weeks at some point, sometime during his 4 days off.
Can I just interject?
Just a second, let her finish.
The visits were also suggested to be supervised, and I don't think that Ms. Downard wants to use the friend of the court visit center. She says she doesn't want to use Ms. Colville, the therapist, as a visit supervisor, and she believes that her son Donovan is a perfectly good supervisor, other than the fact that he did try and bribe Taylor about visiting with his mom and seeing his mother. So I'm just not comfortable with Donovan. But yeah, the visits have got to be scheduled. And
isn't Taylor old enough to be able to look out for his own interest Why would we need a supervisor for a child that's so old?
It would be essentially to ensure that the conversation between Ms. Downard and Taylor is appropriate and isn't being pressured in any way to do anything that he's not comfortable with.
I have a thought on that
He's-
whenever the court would like to hear that.
He's 16 years old. Yeah, go ahead, Ms. McCluskey.
I would just state, like, from I don't think these probably, and I think this is where the court was going. In my opinion, I don't believe they need to be supervised for the reason the court just started to point out. And the fact that in no time did Taylor ever tell me he felt like he needed a supervisor until I spoke to him yesterday. And I don't feel like that came from Taylor. And again, being 16, if he's uncomfortable, he's not going to visit with mom anymore. So that's kind of going to be self-defeating for Miss Downard to make him uncomfortable. And he clearly can remove himself from that situation. So it's just my opinion. I don't think that came from Taylor, and I wouldn't find that necessary.
Thank you. Ms. Downard, you wanted to speak?
Yes, I was just gonna kind of go with what Miss McCluskey was saying with the visitation center. With if Taylor is having issues like having his brother or his grandmother or somebody that he knows personally being a supervisor, I don't see how sitting in front of a court with a stranger is gonna make it feel any better for him. And Donovan has always had his best interest at heart. That is his brother. They grew up together. This is the longest they have not been together. And Donovan did not try to bribe him to come see me. It was a whole, that's a whole different story. But Donovan's comfortable with being around while I visit with Taylor. I've even been willing to go to a park to where, you know, Mr. Gilman and Angela can supervise from afar, or, you know, so that way they felt comfortable. And so, and not leaving it up to Taylor. I don't think it should be up to Taylor, simply for the fact that Kevin's wife, Angela Gilman and Sarah Colville have been putting their 2 cents into it, and it seems to be backtracking every time those two get involved. And I had a child with Mr. Gilman, and that's who I should be talking to. I have no problem with Angela dropping him off or picking him up. We can do it at a police station. I can't drive there for, you know, both ways. It's a 3-hour drive there and back from where I live. So it's an hour and a half there and an hour and a half back. So technically that's 6 hours of driving that, you know, I lose out on with my kid. I'm willing to meet halfway, maybe in Battle Creek or Albion, or to go pick him up, and then they have to come pick him up from me.
So it sounds like those first couple of visits would be okay to occur in a park where Mr. and Mrs. Gilman can also be present, but not necessarily participate in the visit.
Correct.
Is that what I'm hearing? Kevin?
Correct.
What do you feel about that?
I would be okay with that.
Okay. So how many, like 2 visits in a park before we start other visits?
I would leave that up to Taylor to feel, because I'm not going to do anything to make my son feel unsafe or make him want to leave, or I'm not going to make him stay. I don't want to upset his life that he has there. And if he's uncomfortable with me being home, I would personally at 3 o'clock in the morning get up and drive him anywhere he wanted to go. So I believe, yes, the visits, a couple, 3, we'll do 4 just so it's safe, you know, on his end, where, you know, he can be comfortable with me and we can kind of get that bond back before we start thinking about overnight visits.
Okay, so that'd be 4 at a park before you start seeing him in your home, Ms. Downer?
Correct.
How's
Correct.
that sound, Mr. Gilman? 4 visits at a park?
I'm fine with that.
Okay, so Then we've got the first couple of visits with Tasha and Taylor only so that they can rebuild their relationship. So
Okay.
make that the first 4 visits.
Yeah, that'll work for me.
Okay. And then Donovan won't be supervising any visits. He may be around when Taylor comes to your home.
Okay.
Is that sound okay, Mr. Gilman?
Yes, that's fine.
Okay. Now, I've just been notified that Ms. Downard's fiance is no longer her fiance, and although she's living in the house, I'm not sure who's supporting her or how she is supporting herself. And I just wanted to know if that is the case or what's going on, Ms. Downard.
No, we're still together. That's not true. So I don't know where you got that information from, but that's not true. We are still together. We're still living in the same household. We're still a team, and we're not breaking up anytime soon.
Okay. So we'll have the 4 visits with Tasha, and at that point, Sean should be able to get into the picture as well after those 4 visits when Taylor goes to visit Tasha at her home. Does that sound okay?
Yes, that's fine.
Okay. Let's see. Your Honor, I just got the objections from Ms. Taylor Ms. Downard this morning, so I'm just going through with overnights. Overnights in Michigan may somehow be, I think it was out of state overnights, and
okay.
It was, and that was needed to get advance notice, but also advance notice if the overnight's gonna occur like up in the northern peninsula, up north. Can you tell I'm not a native Michigander? Up in the UP. So that so Mr. Dillon has advance notice of that. And if anything happens, we know that there's an 8-hour ride up there, so that has to be agreed on.
Yes, our property though that we go to is over by Traverse City. It's not in the Upper Peninsula. It's about a 3-hour drive with traffic from where I live, which is closer to him.
Okay, so that would be that would not count as an out-of-state visit. So
okay.
But if you are going someplace other than your home, you should be notifying Kevin about where you're taking
Correct.
Taylor.
Correct.
Is that right, Kevin?
Yes.
Okay.
And I'm fine with that as well.
Okay, so then we've got the part about gifts, and we're good with all of that.
Yep.
Now, discipline. It always works out better if there is consistent discipline. And with Taylor's medical needs, his ADHD and some of his other mental health needs, Taylor needs a schedule, a set schedule that he knows what's going to happen, so that he doesn't get confused. And Ms. Downard would absolutely have to have meds for him and that thing.
Yeah.
So Kevin, was there something else about the discipline? Because I think if it's discipline in Mr. Gilman's home, that should continue even at Ms. Downard's home, so that Taylor has a set of expectations that he knows what will happen if he acts a certain way. Mr. Gilman, do I have that right?
Yeah, I guess it kind of came across different in the email than I meant it to. If Taylor doesn't clean his room and I ground him at home, I don't expect Tasha to ground him at her house. That's kind of ridiculous. But if I tell her that, you know, he doesn't get video games or a phone because he has, you know, 10 hours worth of homework that he needs to work on or something with this online schooling and everything, that's something I feel should be transferred to her house as well, because it's school, not just a room or something, you know, trivial like that. So large issues I think should be transferred, but other than that, no, she doesn't have to follow through on clean bedrooms and things like that.
Yeah. And I'm in agreement with that too, Evelyn, that, you know, if he does have, you know, if he's got schoolwork, he's behind on schoolwork, no video games, no phones. I have to do that with my daughter who's ADHD. So I know you know, what it is like dealing with an ADHD child. And I have no problem with if he's in trouble at home because he has homework. I have no problem with him not having his phone or the game or something until he, you know, gets his homework done. But that is the extent as far as like punishment. So I think it would be more of like a structure and a carrying over of a, I don't even know how to say, because I don't want to call it a punishment. And, you know,
set of expectations that he knows what's expected of him, and that those expectations are consistent in either one of your homes, and that consequences will follow if he doesn't meet those expectations. Do I have that right?
Yes, absolutely.
Okay. Did you understand that, Tasha? I don't mean.
Yes. Yes, I completely understand that part of it. Yes.
Okay. So I think we're all through the items that were listed, and I can put it together in the form of an order and get it to everybody for agreement and signature, if that sounds okay to everybody.
Okay.
Mr. Gilman, are you good with that?
Yes, I am.
Okay.
Just, I just have one question. When would we do start the visits, like the 4 visits to the park? Like when would that start?
Kevin, when are you home next?
I am currently home right now. Today is my first day off of the 4, so I'm home today through Sunday, and I go back to work Monday.
Okay.
And I'm available.
Are you guys available for a visit over the weekend?
Not today. Probably Saturday or Sunday would be fine. I know.
Okay, why don't you and Ms. Downer get together for a Saturday or Sunday visit to determine that for this weekend? And please determine that today yet, so that everybody knows what to expect and doesn't make other plans. After that, we could look at your schedule, Mr. Gilman, to figure out when the other park visits would occur, and then the home visits with Taylor after those.
Okay.
Okay.
And
Well,
so
Ms.
do you want me to email
Calagero,
you, Kevin?
looks like you guys are well on your way to having an order. It doesn't look like you need my help anymore today. I will let you do that, and I will watch for the order.
Okay,
And
thank you so
very,
much, Your Honor. So,
Thank you, Your Honor.
very pleased to see the
you.
level of cooperation that's existing between the parents. I think that's a very good sign moving forward. Thank you all. I'm going to move on to the last 2 people waiting in my room.
Okay, thank you so much, Your Honor. Thank you.
thank you.
You're welcome. Good luck to each of you.
Thank you.
The woman with the red hair, what is your name, please?
Lori Snyder?
Lori Snyder?
Yes, sir. Yes, Your Honor.
Okay, give me a moment. All right, and let's see, on the Chromebook, what is your name?
Heather, I'm here for Gerald Smith.
All right, give me just a moment. All right, and this was a motion to terminate a PPO. Give me just a moment to find that file. This is a situation where we have a deceased party to the PPO.
Yes.
Yes, Your Honor.
I'm going to grant the motion. I'm going to terminate the PPO. That's what happens when one of the parties passes away. My condolences for your loss, and we'll make sure we get this order entered. Sorry to keep you waiting for so long for something so simple. Have a good day.
Thank you, Your Honor.
You're welcome.
Thank you.
Are you